side. So at
Yeah.
12 o'clock, we'll take just a break for 5 minutes so that Brother Call also can just stretch around a little bit.
Thank you. Thank you.
If you feel that, you have to take a little break earlier to just stretch, please just tell us. We'll immediately take a break.
Seems I'm doing fine to that limited extent. Okay.
Perfect. Yes, Ms. Nandi.
My lords, my lady. Brief note. It's not one page.
I wanted to appeal to all the members of the bar that now that, we are dealing with CBs, all my colleagues and I as judges, we feel that there should be some cutoff beyond which every morning we can't have, 600 MB files and, huge papers being filed every morning. Then even for the other side, then it becomes very difficult for them to anticipate what they have to prepare.
Absolutely.
So we must have a cutoff when the arguments start. Then thereafter, if something exceptional, one wants to file a short note or something, that's different, a 2-page, 3-page note. But basic material shouldn't come in, every time, every day of the hearing. All right, but we'll set up that protocol. Yes, Ms. Nandi.
My lords, I filed a 3-page note.
Yes.
We didn't keep it to 1 page, my lords, though we could have, only because for the convenience of your lordships, we wanted to reproduce the paragraphs that we are referring to rather than jump between.
So, Ms. Nandi, what are the submissions? Can you formulate your points?
Yes, my lords. My lords, I seek a declaration that includes my rights as queer, non-heterosexual, and same-sex people to marry under the secular legislations, the Special Marriage Act, the Foreign Marriage Act, and provisions for OCI card holders only under the Citizenship Act. My lords, I will briefly go through what I will be covering and then go to the last point first. Number 1,
OCI card
Special Marriage Act deals with...
Volume 7 hai kya?
It's the tabulated form.
Even I have a tabulated submissions dated
That's all I have.
23.
There are 2 tabulated forms. One is 26 for one.
No, there's just this one form, my lords.
Both
with
justice.
pages.
Both justice.
the cover pages. The cover page is 1 page. The submissions are 3
I got the
pages.
same thing.
Summary of arguments.
That's 3 pages, right?
It's 3 pages.
Summary of arguments.
The cover page is 1 page, so the PDF may be showing 4,
Yes.
but it's in bullet points. We all have our preferences, my lord.
Yes,
It
yes.
had fell from my
Brother
lord's
Call,
hand.
Brother Bhatt, you have those 3-page submissions?
I have a 6 or 7 page, 6 or 7 pages. I don't know.
It says submissions dated 26/4/2023, correct?
Yes, my lord.
Yes.
The 12-pager and
It will be in compilation 1, volume 7, my lord Justice Bhatt.
Yes, volume 7.
My lord Justice Call has it.
I have it. Mr.
Ravi, do you
Yes,
have it?
madam.
Brother Bhatt, do you have it?
I don't know whether I have volume 7.
It was.
It says submissions dated 26/4/23, 2023. ये renumber किसने किया है actually?
It's a table, my lords.
Yes,
No.
It's a table with bullet points.
217 KB.
Why don't you email it to Justice Bhatt? Brother Bhatt, the court
Maybe
will just email it to you.
Where is it? Is it in liquid text? Now you've given.
Justice, but I have mailed it to you.
Okay. Yeah. Yes, I have.
Got it? Okay.
Yes, yes.
Grateful, my lords.
All right.
So, my lords, I am seeking a declaration that includes my rights as queer, non-heterosexual, and same-sex people to marry under the secular legislations, the Special Marriage Act, the Foreign Marriage Act, and provisions for OCI card holders under the Citizenship Act that constitute a self-contained part to grant entitlements based on registration, recognition of foreign marriages. My lords, I will briefly describe the first two sets of points and then deal with the third first. Because nobody has
Now
dealt
let's
with
see
the
the
third yet.
summary of submissions.
I beg your pardon, my lord?
Let's go through the summary of submissions now.
Yes, my lords. First, my lords, under the Special Marriage Act, it has been submitted that 99.9% of people fall in the gender binary and are men or women, whether they are queer or trans or straight. My lords, we adopt the other arguments of Dr. Singhvi, but my lords, on this point, we differ. The 2011 census itself showed that there are at least 4.8 million, and this is a huge underestimate, my lords, of trans people in this country. Many of them, my lords, are in this courtroom, and I mention this because of the way that they have been demonized in the public. Ms. Muskan Tibrewala, who has rendered excellent assistance, is one such person who is going through a coming
your
out
point
space and has
number
given this
two,
permission to
your
me.
first point is you have referred to section 3 and section 2K.
Yes, my lords.
It's the 3 speaks of non-discrimination against non-binary persons. That's fair enough.
Yes.
Then the next point which you were saying, that is, just explain that. You say that rule 5 of the transgender rules already recognizes marriage of trans persons. What is the, can you read out the rule for
My
a
lords,
second?
there are the rule.
Is a rule in that book?
Can I have the rule?
Should I see
Rule is in the
the
book.
rule?
Can I have rule 5?
Yes, it is, rule is there.
These are-
Where is it? It's not 3 pages. No.
Yes, here it is.
Rule 5, right?
Yes, my lords. My lords, rule 5 refers to the application for certificate of identity. Do my lords have it?
Yes, we do.
No, but rule 5 says issue of certificate of identity, right?
What? 6 is issue of certificate of identity, my lord.
No,
No, 5.
5.
Take time to download.
We have the 2023 Act, my lord.
No, we have a 2020 rules.
I mean, we have the 2023.
Same rules.
Yeah,
Rules have changed.
2020 rules.
The
If
Act.
you saying that 23,
I beg your pardon, my lord.
rules are 2020, right?
Issue of certificate of identity for a transgender person under section 6.
No. 6 is procedure for issue of a certificate of identity. 5 is issue of certificate of identity. Right?
Yes, ma'am.
Which one are you looking at, 5 or 6?
My lady, under these two rules, a certificate of identity is issued to trans people.
Yes.
In that regard, an affidavit is required to be submitted, and the form of that affidavit is provided in the rules itself. So it is the forms that I am on more than the rules. The rule is the power
Right.
to issue the form, and I am now on the form.
But when you say rule 5 already recognizes marriage of trans persons. Where do we get that from? Because that's an important point.
My lord, it's more that the form acknowledges.
Where is the form? Which page is the form?
Form is at page 3224.
No, it's here also in the
It's
your
been-
form number.
Justice, and page 17 of this act, if you
Or
have it.
the form is
Form
at
Actually,
form 2.
Form
Justice,
5.
I think let us focus on page 17 of the Act.
I
Yes.
beg your pardon? Oh. I'm sorry, my Lord Justice. I can't see the judge.
You have the enactment, so you can see the Act. Page 17 contains the form.
Yes, that's what it is. Form 1.
Right.
Yes, form 1.
2D, 3.1 and 6.1. So we suppose this is the form you are relying upon to say that.
The next
it
page, my
recognizes
lords,
the
is form 2. I have page 19. I have the 2023 Act.
That's fine.
It's a 20.
23 Act.
What
There's
is
no
this
23 Act.
23
It's a
version.
2019 Act.
2023 version.
Yeah.
It is the 2019 Act.
Right.
But because I'm referring to page numbers, this is the version that I have.
Form 2.
Form 2. Form 2, do my lords have it? It says,
We do.
the form of affidavit to be submitted by a person applying for certificate of identity for transgender persons under Rule 4 of the Transgender Persons Protections Act Rules 2020, read with Section 6 of the transgender persons
Most
protection of
important is
life.
I perceive myself as a transgender person whose gender does not match with the gender assigned at birth.
Yes, my lords. I declare myself as transgender.
Right.
But the top part says, I, so and so, son slash daughter slash ward slash spouse of.
Right. So a person who is already in a marital relationship
Yes.
can therefore seek a gender reassignment, like
Or
by
a
virtue of form.
self-declared identification. Precisely what has fallen from my lords. Indeed, as my lords Justice Bhatt has said, there is no, some people may seek a divorce pursuant to this. Many people in our society will not. And there is no bar in this regard in the Act, and the Act is
So
silent.
it already recognizes the, say, a pre-existing marriage of a person who is trans.
My lords, the pre-existing marriage, but also the subsisting marriage. Because when
right,
they
right.
transition and after
Subsisting.
they transition, it continues to subsist.
Correct. There is no bar in law.
Right.
Then there is no bar in law.
Somebody who seeks to assert their identity as trans
Yes.
may well be in a marital relationship at the
Precisely.
point of time when they assert that identity.
Yes. But they also continue to be in that relationship.
Right.
And that relationship under law is not dissolved or annulled or taken away from them.
Yes.
The law accommodates it because these are not grounds for nullity or divorce by the other spouse, because there are possibilities, various marriage possibilities, that there could be children, there are dependent families. So there's general acceptance. If somebody has a problem, they will seek out in individual cases whatever needs to be done.
I'm grateful, my lords. That's exactly our point. My lords, there is another mention of this in Form 6. And the illustrative list of documents on the next page includes a marriage certificate at item 12.
No, this applies only for both this and Form 2 will apply to married people who seek that identity as transgenders.
Precisely, my lords.
Right? These forms accommodate such people.
Yes, my lords.
The rule makers have contemplated situations where people seek this gender role, or rather regender themselves, if one could use that expression.
Yes, my
To
lords.
the extent they recognize and acknowledge that there could be pre-existing marriages.
Yes, my lords.
Mr. Nandi, is it your case that because the rules recognize the concept of a pre-existing marriage in such a scenario, that itself amounts to a permission to have a marriage after such change? Is that what you are seeking to? So, see, there's a pre-existing relationship which will continue. As Justice Bhatt said, it may not dissolve because there may be many ramifications which may arise from such declaring the marriage a nullity or something. So it accommodates that viewpoint. But does that imply that after change, if suppose you are unmarried and there is a change, you can marry? Is that what you are trying to say?
No, that would be my set of arguments that I have made in my larger written submissions, my lords, on constitutionality and harmonization. But my lords, that is precisely right. What I am saying right at this point is that the state already recognizes through delegated legislation and the forms that have been issued under that delegated legislation, some trans marriages, and that some at the moment is restricted to marriages that were pre-existing prior to my declaration of identity
Be clear
or
that
transition biologically.
The marriage recognition is
Yes,
between the marriage was solemnized at a time when both parties were not trans. Neither of them were trans.
True. But it subsists because
Let-
there is no bar-in-law as had fallen from my lords.
Let me complete. Perhaps there is no ground for divorce in marriage laws. Therefore, there is a recognition of the fact that once somebody finds himself in this situation, we will not disturb it. Because once you start disturbing, there could be other consequence. So you recognize that situation.
Yes,
That is one thing to accommodate in the form of rules or even forms. No, we are not talking about rules. We are looking at forms.
yes, my lords.
If we are to transform that into substantive provision and work backwards, as it were, there should be some statutory support for that.
Yes, my lords.
Because unless you state that, for instance, Section 3 or whichever provision says there shall be no discrimination, and then goes on to say in what aspects, like you
You
have in
can
Section
still continue
47
to be
of
married.
Disabilities Act. So
Yes,
what
ma'am.
are the rights and what are the obligations, what rights of these persons who claim these identities, and what are the obligations of society? The legal obligations are also spelled out. So if your argument is built around these forms, then you'll have to go further.
My lords, the argument is precisely the way that had fallen from my lords, Justice Bhatt. We have said, for example, that it has been said in this court, during these proceedings, that trans and non-binary people are elite, that small portion, etc., my lords. The
Ms.
first point addresses that. The second point is on the non-discrimination, my lords.
You know, this elite argument you can just keep aside because we are now going into the core constitutional issues and core statutory issues.
Yes, my lords.
So, you know, elite is a matter of prejudice. I mean, but it has no bearing on how we decide the matter.
I'm grateful. Let's place
Actually, you
that
know,
aside.
these two forms which you showed us, the first form, Form 2, is at the stage when you apply for a gender identity certificate.
Yes, my lords.
Form 6 is after a gender as reassignment takes place. Because if you see Rule 7.4,
With the ID.
Form
Yes.
Form 6 is to be read with Rule 7.4 because that's you know, that's in the title of Form 6. And 7.4 says the district magistrate, while issuing the certificate of identity for change of gender, shall simultaneously issue an identity card in Form 6 to the applicant.
Yes, my lords.
And that form in item 12 refers to marriage certificate. So these two forms seem to indicate that both when a person applies for a gender certificate in Form 2 and the issuance of a reassignment in certificate in Form 6, they do contemplate that somebody could be a party to a valid marriage because they or an subsisting marriage.
The
Precisely.
position as it existed at the time of the grant of the certificate is what is contemplated, without anything more.
But also, as my lord, the Chief Justice had pointed out, that after the gender reassignment surgery is done, the situation is different.
Correct. This is
And then,
No, but Ms. Nandi, if you see the Act also,
yes, my lady.
Section
Yes, it is.
5, 6, they refer to application for certificate of identity. They refer to issuance of certificate. 7 talks of change in gender and specifically says that it is, if you will read that an application may be made along with the details of the institution where the person has undergone surgery. So the whole idea is so that the certificate can be revised. The context is of 4, 5, and 6 is issuance of certificate of identity.
Yes, my
In the course of that,
Yes.
the status of that person, as it were, is reflected from one of the columns, but that's about it. So how do you propose to take it further?
My lady, the
Build your
point is this. My lady, what I am saying is this, is that the law recognizes under Section 2K the range of gender identity. In Section 3, if we may come to that, (3)(e) specifically,
Yes, please.
Prohibition against discrimination, 3E says the denial or discontinuation of or unfair treatment with regard to access to or provision or enjoyment or use of any goods, accommodation, service, facility, benefit, privilege, or opportunity dedicated to the use of general public or customarily available to the general public. So it's a broad non-discrimination provision. In addition, and this is my third point, that this is not happenstance.
You're right, it's not happenstance.
Because of Nalsa, my lady.
But then this is a right which is available under 15(2) to some extent.
Precisely, I'm grateful to my Lord's Justice for this.
Don't need a NALSA. 15(2) encapsulates that. It's a wide horizontal right, right? So, I mean, to take your logic, let us go to Rule 5. Rule 5 talks of issue of certificate of identity. Right? It says the certificate, number 3, sub-rule 3, certificate of identity issued under sub-rule 1 shall be the basis of change of gender as well as the name and photograph if so necessitated in all such official documents as provided in Annexure 1. Yes. Now, what is Annexure 1? We don't have that in this.
Annexure 1 is perhaps what is at page 23. It refers to Annexure 1, brother. Card issue date, signature
Annexure
of
1 is there.
Annexure
Same
1
thing.
is illustrative list of official documents referred to in the name of the official document.
It's titled Annexure 1, as my lady has pointed out, above the table.
Page 23.
It is Annexure 1.
No, it's not.
It's a part of Annexure 1.
Annexure 1 is not part of
No.
Form 6. It's an independent annexure. And this is something relatable to Rule 5.
Yes.
So, just to take the thought further, Ms. Nandi, not
Yes,
everyone has a marriage certificate. Not everyone has a marriage certificate.
Yes, my lord.
You agree?
Yes, my lords. Not everybody has a marriage certificate. Some transgender marriages continue to subsist.
No, I'm not talking of that. I'm talking generally.
Yes, my lords.
Matrimonial,
Yes, not everyone has a marriage certificate.
because marriage certificate is a civil kind of form which is not mandated by any personal law. There is no compulsion except maybe in some states.
Absolutely.
Certificate. The only certificate which is mandated is under the Special Marriage Act, because that is the only form of marriage between those two classes of persons who belong to different communities, right? So a marriage certificate itself might pose a problem for anyone.
Yes, my lords.
Yes.
My lords, I am only pointing out the current situation and
Yes.
pointing out that currently that there are some transgender marriages that at the point of transition are recognized to subsist. There are other transgender marriages that are not. Either they do not have the marriage certificate, or they cannot marry the person they love only because of the timing. That is my point, my lords.
See, that point is, I mean, you have made your point, but the point, there is a distinction, which is that those who are married as not transsexuals, as heterosexual couples, a heteronormative based marriage, so to say, later turns out to be one where one recognizes her gender not as a female or male, but as a transgender person. At that stage, the law enables this much, and it also does not upset the pre-existing.
Yes, my lords.
Exactly. Now your dilemma is the next step, which is that having recognized the pre-existing relationship, you have not enabled two transgender persons to come together and celebrate their union an
Yes.
argument. That is your dilemma.
Yes, my lords.
Where you're saying, no, you can't locate that within the enactment. To the
We are
extent
not.
that
We
the
are
law
not.
recognizes this,
Purpose of
but you have to go beyond that, and there you have to fall back on the same arguments which are made by your predecessors.
By many counsel before me and by me, but I will not repeat them in the interests of brevity, my lords. But that is precisely, my lords, what our burden is, to discharge the burden of constitutionality as it relates to the argument that goes beyond the forms. And my written submissions, my longer written submissions, which is in compilation 1, address all of those arguments as well, my lords.
What is the next point?
The next point, my lords, is just to say that this is not happenstance, that the Transgender Act of the Union, not so long ago, only 4 years ago, was enacted pursuant to NALSA. And what NALSA says at para 119, and I've reproduced the part for convenience, that therefore gender identity becomes a very essential component which is required for enjoying civil rights by this community, viz. the right to vote, the right to own property, the right to marry. On workability, my lords, on workability, I have worked it out, and my respectful submission is that there are only two doctrinal principles that need to be applied for a minimal reading in. The first is this, that husband and wife should not be collapsed into the same category, my lords. And there should not be one gender-neutral category of spouse. Because the heightened protections that are given to women emerging from Article 15.3 are there for a reason. So what we have proposed in this note, but the reason we didn't file it because we would like to hear what the other side has to say. But this is the current formulation. Is that third gender spouse, which is a phrase used in NALSA. It has been critiqued. So non-binary can also be used in this regard. May be used along with husband or wife. And of course, husband or wife must include trans husband or wife. As the Madras High Court did for the Hindu Marriage Act in Arun Kumar, that judgment is in my compilation. I'm not going into it because it's the Hindu Marriage Act. But that's the way the Madras High Court had worked it out. The second doctrinal principle, my lords, is this, that
can you send this on email to the court master so that he can then email it to justice?
we will do it in the next 10 seconds. We weren't planning to hand it over, my lords, but...
So you are saying, I'm sorry, Ms. Nandi, there was a lag here. I think perhaps Justice Kaul also explained.
Yes, my lord. Shall I repeat what I said, my lord?
First you said that you do not want a neutral phrase like spouse. You don't want to collapse the gender
Basically,
enactment
basically
because
the Brother Bhatt and Justice Call,
Yes.
what Ms. Nandi's the tabulated statement which she has given us now,
Yes.
seeks to interpose the word or third gender person
Uh,
in various provisions of the Act, including Section 2B. So, for instance, in 2B, she says a man or third gender person. Likewise, a woman or third gender person. In Section 4, which deals with conditions relating to solemnization of special marriages, the male has completed the age of 21 years and the female or third gender person, the age of 18 years. Likewise, in Section 12, I so and so take B to be my lawful wife or husband or third gender person. So,
Under spouse.
then spouses instead of husband and wife. In Section 20, in 15, husband or wife or third gender spouse in Section 22.
So I think it goes on then.
That goes on, exactly.
So
Just to
then,
emphasize, my lords, that I used third gender because it comes from Nalsa and it has precedent in law. But it has been critiqued by the communities. And so non-binary would serve just as well. Non-binary person or non-binary spouse.
Ms. Nandi, so then you
Hello.
comment that the approach of the Madras High Court should be adopted in regard to all this. We understand that. The only question is where do you perceive the conflict between your position and the position by the predecessor council? Because that is something we have to iron out.
Yes, my lords. My lords, the Madras High Court supports this workability note only to the extent that man or woman includes trans man and trans woman. What we have added here, my lords, is non-binary persons based on two doctrines: differential protection for women to be preserved, and that heightened protection also be provided to non-binary transgender persons due to the fact that in line with Article 15.2 to 15.4, NALSA requires the union to provide special provisions for transgenders and affirmative action as social and economic backward classes. So there is a ground because of historic discrimination in para 67 and 68. Read out the paras. This is at volume 1. Shall I come to that, Manu?
Yes.
This is volume 1, compilation 4, PDF 792, and paperbook para 761. I'm on para 67. Transgenders have been systematically denied the rights under Article 15.2, that is not to be subjected to any disability, liability, restriction or condition in regard to access to public places. Transgenders have also not been afforded special provisions envisaged, and my lords may note envisaged already, under Article 15.4 for the advancement of the socially and educationally backward classes, SEBC, of citizens, which they are, and hence legally entitled and eligible to get the benefits of SEBC. State is bound to take some affirmative action for their advancement, so the injustice done to them for centuries would be remedied. Transgenders are also entitled to enjoy economic, social, cultural, and political rights without discrimination, because forms of discrimination on the ground of gender are violative of fundamental freedoms and human rights. Transgenders have also been denied rights under Article.
All right, Ms. Nandi, we've seen Talsa. Now, should we go back to your statement, actually, so that, that's page 2, so
Yes,
that we can just look at it and then we can wrap up, I think.
My lords, I have 2 additional points, if I may, and my third point is one that nobody else is raising.
Yes.
So I'll go through this very fast and then come to my third point.
Yes.
So 15.2 to 15.4, my lords.
Where are you reading?
Differential.
Where are you
Which
reading in your
part of the statement are you on?
which page of your statement?
I finished page 1 and I am turning to page 2 to deal with the Foreign Marriage Act.
Yes. Okay.
My
The
lords,
submission
should this
26.
court only read the Special Marriage Act inclusively, an immediate Article 14 anomaly will arise. The statement of objects and reasons in the Foreign Marriage Act explicitly and repeatedly states that the FMA is pari materia to the SMA and incorporates provisions of the SMA by reference. So the FMA applies when one party is an Indian citizen and the marriage is solemnized outside India. So for clarity, it doesn't apply to 2 foreigners. However, the same Indian foreign couple may come to India to marry under the Special Marriage Act because the judgment that I have placed on record, and I've only placed one, it is of 2023 by Justice Pratibha Singh, and she has detailed the other case law that also says the same thing. And it holds that even two foreigners, male and female, can marry under the Special Marriage Act, because Section 4 uses the term any two persons and not citizens. So if the Foreign Marriage Act does not follow the Special Marriage Act in being read in a gender-inclusive manner, same-sex, queer, and transgender couples may marry in India, my lords may scratch out or at a consulate, may marry in India, but if they are already married on foreign soil, they will not be able to have their marriage registered by an Indian marriage officer under the Foreign Marriage Act, Section 17. The reason is that 17 refers back to Section 4. And Section 4 is the only place where gender-specific terms bride and bridegroom have been used. And we have done this workability exercise, my lords, and placed the Foreign Marriage Act provisions also under the table that we have submitted to my lords. We will refine it if required, if there are submissions in this regard from the other side. But my lords, the rest of the Act, if Section 4 is read inclusively and in accordance with a declaration or the Special Marriage Act, falls almost automatically into place.
So then now your final point, which is?
My final point is that there is a third category of persons. And this third category of persons are represented only in my petition. They are left in a catch-22 situation. We are married OCI persons with families who choose to live here. Some of us, and some who have deep roots in this country. Many have been Indian and then moved abroad and, I beg your pardon? And become OCI. They cannot marry under the Special Marriage Act because the third schedule requires a declaration that one is not married. They cannot marry under the Foreign Marriage Act because that only applies to an Indian citizen marrying a foreign citizen.
Who is there before us of that category?
So before you, my lords, are Kamakshi Raghavan and Melissa Ferrier.
Want to see if any of those people fall in the category that you are mentioning.
Yes, my lords. My lords, if I may have the leave of the court to say a little bit about Kamakshi Raghavan and Melissa Ferrier.
You said that they cannot marry under the SMA because the third schedule applies to persons who are not married.
Yes.
And they cannot marry under the FMA because?
One party must be Indian and one party must be foreign. Here, for my petitioners, one party is OCI and a foreign citizen, and the other party is foreign. And if I may tell, as had fallen from my Lord Justice Bhatt, just a little about Kamakshi and Melissa.
Yes, we can. Can we decide constitutional validity on individual cases? You know, I mean, validity of a provision doesn't become suspect because if it causes injustice in individual cases. You have to look at the constitutional validity of a provision from the larger perspective.
Shall we look at the plain words of the provision, my lords? But first, if I may tell my lords a little bit about this couple.
See, we have
with my Lord Justice Bhatt's permission, if I have time in the end, shall I do that? And shall we go to the section itself?
Classical statement of law was by Justice Krishna in R.S. Joshi versus Ajit Mills that you know.
My lords, I am on constitutionality. Hardship is only a supportive argument. And constitutionality...
My question was not an invitation to outline the facts. Because when we are deciding, none of the previous council have outlined any facts. Except the barest minimum. Because if we are to, then we would delegate this matter somewhere else. To tell us how this The only thing, one sentence, how is it relevant or is it not in your petition? If it is not, it is moot. Why should we decide it? If it is, then you say so and proceed. That's all.
So why don't you summarize now, as we are concluding, give us the core of your submission. Why don't you summarize it now so that we can then note it and then we'll conclude.
Let me summarize my submission with regard to the Citizenship Act. As had fallen from this Honorable Court and from Justice Bhatt in particular, that is there a segregable provision with no prohibition in the enactment in which certain things which can be done straight away without entering other arenas in enactments where there is no express prohibition of the remedies sought. I have reproduced Section 7A1D of the registration of overseas citizens of India card holder in the note itself. My lord, we have also requested the courtmaster to keep the act ready. The provision is clear. If I may read it briefly. Registration of overseas citizen of India card holder, the spouse of foreign origin of a citizen of India. This would, or if my lords find in my favor in the Foreign Marriage Act, this would automatically be recognized. Or spouse of foreign origin of an overseas citizen of India card holder, registered under Section 7A and whose marriage has been registered and subsisted for a continuous period of not less than 2 years, immediately preceding the presentation of the application under this section. 2 requirements, therefore. 1, that there be a valid marriage in another jurisdiction, and 2, that it be subsist for 2 years. And then subsequently, provided that for the eligibility for registration as an overseas citizen of India card holder, such spouse shall be subjected to prior security clearance by a competent authority in India, and provided further that no person who either of whose parents or grandparents or great-grandparents is or has been a citizen of Pakistan, Bangladesh, or such other country as the central government may, by notification in the official gazette, specify shall be eligible for registration as an overseas citizen of India cardholder under this section. There is case law, very briefly, my lord.
Consider Section 7A, yes. You've extracted it here, we'll see.
My lords, if I may just have 1 minute
Yes.
to point out the case law that already exists. There are a variety of high courts have found that nothing can be read into this provision. In Nadidi Eze, he was an illegal immigrant and they said there is no bar in this particular section, etc. In Yossi bin Ari's case in Israel, they said that the registration official is not competent to determine whether there is a legal or social framework.
Nandi, thank you. Yeah, yes, now we'll hear.
I'm extremely grateful, Nandi.
I'll get right to it, my lord. Your lordships had raised certain questions yesterday. My endeavor and my time will be only to address those questions. Whatever points I've raised in my submissions earlier are already there with your lordships. I had also circulated, I should say, an additional note this morning. It's the note dated 26/4/2023 in response to queries raised by this honorable court during the hearing of yesterday's date. Do my lords, it's volume 10 of the folder titled Written Submissions. That's the first folder.
Yes.
Do my lords, Justice Bhatt and Justice Kaul have it?
Yes, I have got it.
I'm most obliged. I'm most obliged. As I understood the proceedings, can I move on?
Separate folder. Where is it separate? Don't download it at all. Just check it.
While my Lord Justice Kohli's laptop is being uploaded, can I just summarize what I've understood?
Please go ahead.
Please, my Lord, I'm obliged.
Yes, please.
My lords. As far as the constitutional issues were concerned, those were clearly set out before my lords, Article 14, 15, 19, 21, etc. The case law is also clear before my lords. There was then a question of interpretation of the statute. Now, there are various provisions of statutory interpretation in my lordship's arsenal, both the principle of updating construction as to how to read, reading up, reading down, and so on. The question which I understood falls from my lords is how far my lords will go in their interpretation of the statute. At the heart, there are certain provisions of the SMA. So we left out personal law in terms of the Hindu Marriage Act altogether. At the core, there were certain provisions of the SMA, Section 2, Section 4, Section 27, 36, 37, and so on, which were read by my learned friend, Dr. Singhvi. And there, the proposition that broadly has emerged is that my lords can read the words my lords can read the words husband and wife, bride, bridegroom, etc., insofar as they occur in the statute, either in a gender neutral manner or by reading in the word spouse. So the general proposition then is that there is an act of reading in, an act of expansion of the statute to include a hitherto excluded class, which both updates the statute in terms of present day reading and understanding of relationships, and secondly, brings it in tune with our current understanding of the Constitution. Now, my lord, the questions which fell from your lordships yesterday pertain to, firstly, Section 21A of the Special Marriage Act, which I've sought to address in this note I've now submitted. And the question that follows is, to what extent do my lords then retain personal law for LGBTQ couples who may marry under this statute, who may be similarly placed to other couples, that is, opposite sex Hindu couples to which Section 21A applies? That is the first question which your lordships raised yesterday and which I believe is troubling your lordships. The second question is a more general question, that when we look at general civil statutes that relate to the rights, what we are so far calling the rights and obligations of marriage, to what extent will those apply to LGBTQ couples who marry under the Special Marriage Act? So we are confined, my lord, to the Special Marriage Act. But the question is, what are the consequences of the interpretation that would follow if your lordships were to decide in favor of the petitioners? Now, I will take my lords through my reasoning as set out here for both the first and the second question. But the conclusion I'll come to is this, that your lordships cannot decide every question today. The statutes, whether we talk of gratuity, as my lords did yesterday, pension, there are any number of benefits that and obligations that flow for married couples, or whether we speak of the consequences of 21A, these, my lords, are complex statutes, and LGBTQ couples, as it fell from my Lord Justice call on day one, LGBTQ couples will come to your lordships, and more importantly, in fact, to the courts below, to family courts, to civil courts, and to the high courts with questions of statutory interpretations as they raise claims and they seek the protection of law in the same manner as opposite sex couples do and have done now, perhaps since the codification began of matrimonial laws starting from the early 1800s onwards. So we are no different in that regard. In fact, if I may say, what we ask for today is the right to not be different, that our differences stand ameliorated by our inclusion under this one statute. So what your lordships have said so far is that the application of the Special Marriage Act would be expanded, and then it would apply to us as it does to all other couples. That, my lord, is my submission, would continue to be the reading for 21A and for other general civil laws. And what I would submit, my lord, is that a declaration, both a positive declaration in the form of mandamus and a negative declaration in the form of prohibition, would go a long way in easing the work of the courts below in the interpretation of the statutes, as they must now commence doing in the work that they will have to come. If my lord will see, I have set out that declaration at the very beginning of the note. It is first, my lord, do my lords have it? In paragraph 3.
Paragraph 3. Yes.
My lords have it? Justice Kaul and Justice Bhatt?
Yes.
I'm obliged. I'm obliged. So we seek, my lord, first the positive declaration that a marriage solemnized or registered, it would be solemnized, I apologize. Marriage solemnized under the SMA 54 and the parties to the said marriage shall be entitled to all the rights and obligations conferred on a married couple or a party to such marriage under any other state or central law, notwithstanding the gender identity and sexual orientation of the couple. And your lordships would also, I propose, give a negative declaration binding the state that the state nor any authority of the state shall deny rights and obligations conferred on a married couple or such party, and then the formulation is the same under the Special Marriage Act only on the grounds of sexual orientation or gender identity.
Yes.
With this groundwork in place, my lords, I'll now come to the first question which fell from your lordships yesterday. And my lords, let me say, it is not a light question. It is not a question to be easily decided. It is not a light question for us to consider either, to contemplate. As far as Section 21A is concerned, I would first submit that on a statutory reading, in terms of the application of the principles of statutory interpretation, which your lordships will consider, 21A will apply to same-sex or LGBTQ married couples who marry under the SMA in the same manner and with the same force as it would apply to an opposite-sex couple. Now, for my lord's convenience, I have actually set out the section in the note itself, but we can take it from the statute as your lordships prefer. May I read for your lordship's
Yes.
benefit? It's, my lord, at page 5 of my note. There's a table set out, but otherwise, if my lords have it, I'll just go ahead. Special provision in certain cases. Where the marriage is solemnized under this act of any person who professes the Hindu, Buddhist, Sikh or Jain religion with a person who professes the Hindu, Buddhist, Sikh or Jain religion, section 19 and 21 shall not apply, and so much of section 20 as creates a disability shall also not apply. Now, my lord, let's read the chapter starting from section 19. Section 19, my lords, the marriage solemnized under this act of any member of an undivided Hindu family, an undivided family who professes the Hindu, Buddhist, Sikh or Jaina religions shall be deemed to effect his severance from such family. And let me say, my lords, that the membership of such a family is not something which we take lightly. It is an important part, my lord, of the way in which we see ourselves as members of the family and as society. But, my lord, section 20, subject to the provisions of section 19, any person whose marriage is solemnized under this act shall have the same rights and shall be subject to the same disabilities in regard to the right of succession to any property as a person to whom the Caste Disabilities Removal Act 1850 applies. I'll take my lordship to the Caste Disabilities Removal Act also. Section 21, succession to properties married under properties of persons married under the Act. Notwithstanding any restrictions contained in the Indian Succession Act with respect of its application to members of certain communities, succession to the property of any person whose marriage is solemnized under this Act and to the property of the issue of such marriage shall be regulated by the provisions of the said Act, and for the purposes of this Act shall have effect as if Chapter 3 of Part 5, special rules for Parsi successions for interstate, had been removed therefrom. Now, my lords, what is the overall effect of this chapter? Firstly, upon marriage of a Hindu, Buddhist, Sikh or Jain to a person who, in light of section 21, is not a member of that faith, you are severed from the joint family. Secondly, my lord, these disabilities under this Caste Disabilities Removal Act, my lord, of 1850 is saved under section 20. Thirdly, my lords, I am removed from the operation of the Hindu Succession Act if I marry a non-Hindu, and now placed under the Indian Succession Act, as fell from my lords yesterday. But 21A, if we come back to it, it has the effect, firstly, of saying that 19 and 21 will not apply to me if I marry another Hindu. And secondly, it does not apply to non-Hindus, that is, persons of other religions who may marry within their faith. But 19 and 21 apply to those persons.
Ms. Kaju,
My lord.
I think there is one caveat there.
My lord.
Whereas you are right on the first part, the second part will have to be seen loosely, because you are presupposing that there could be other two same-sex couples from the same religion.
My lord.
Have a Christian and a Muslim,
My lord.
Christian and a Parsi, or a Jew and a Muslim, or whatever. So
My
all
lord.
limitations are there,
My
which
lord.
means to that extent you will have to look into the provisions of the Succession Act, concerned provisions of the Succession Act to start with, and other personal laws. Now that
Yes,
is
my lord.
one complication. And the second is, you are very right in straight away stating that, you know, the Hindu Succession Act will apply, or whatever laws of Hindus will apply to uh, to same-sex couples who are both Hindus. But that means necessarily, willy-nilly, we will have to interpret. And there, like all of you keep repeating, life doesn't wait. So if there is an unforeseen circumstance like an accident in the absence of a will, or something else, then necessarily the spouse stands excluded. Either Section 8 or the rules of succession of females, or we don't know what other complications are there in other provisions.
And may I say, my lords, perhaps today we cannot know. And we must, I say this with all humility, having considered various aspects of this matter for many years, that all aspects of or questions which may arise before the courts are not clear to us today, as they are not in any case. Your lordships have time and again gone back to the institution of marriage as codified under various statutes and read in various nuances which arose with the passage of time. So as fell from my Lord Justice call, these questions we will be here time and again. But as far as this question which my Lord Justice Bhatt raised, yes, there will be couples who are LGBTQ and, my lords, who are interfaith couples. And there, my lord, 21A will apply to them as an interfaith couple. And there will be couples, my lord, who are Hindu and LGBTQ. And there, my lords, 21A will apply to them as a Hindu couple. Your lordships are not required today to further read the act beyond reading in and explicating the word spouse.
We look at,
my lords, my
yes,
lords.
Miss Karju,
My lord.
then jurisprudence of this court, which has dealt with provisions of law and their constitutionality, has never isolated one provision. You
My
take
lord.
it to minorities, in the field of education. When an enactment is there, the organic whole has to be seen in the context of a challenge to the concerned provision.
My lord.
World Control Act, which was seen in the 60s, or even Frank Anthony, which examined the entire provisions of the Delhi Education Act to see the impact on one section. So there is an organic whole. So to isolate one would not be in consonance with this, the approach of this court. That would be leaving things half done, mostly undone. Therefore, how this has to apply will have to be ultimately taken on by us at one go. That's one way of looking at it. All of you have been consistent saying that these are battles which will be fought later. But that does it absolve us of the duty of constitutional the obligation of seeing and considering doctrinally the impact of one provision over the other, or many provisions over one? That you will, that we will have to keep in mind.
My lords.
All of you have given one picture, that
My lords.
the rest look at only this, and this is what we want.
May I submit?
Actually articulated the positive and the negative part. So I think it, in a way, summarizes the entire, let's say, project.
May I say, my lords, that my lord may be right. As a matter of constitutional explication, the constitutional underpinnings must be taken through to their logical end. But my lord, as far as one provision or the other is concerned, I may say that in my own reading of and research into 21A, aside from one judgment before the Honorable Delhi High Court, in 84, we did not find any other challenges, my lord, to the constitutionality or otherwise of 21A. I would submit that it poses no problem because it is a part of the seamless whole of the statute as it stands today in light of the legislative developments that have taken place since 1850. So if my lords will permit, I'll come to my second point, which is on the evolution of the law of special marriage,
Yes.
which commenced, my lord, in 1872. And prior to that, my lord, we would just shortly consider the Caste Disabilities Removal Act of 1850.
Arundhati, Mr.
So
Kajal,
if I, my lord,
you know the questions that we have asked. You just formulate your points.
my lord,
And then what ideas you have,
my lord,
suggestion you have,
my
you
lord,
can just
my lord, I'm very,
right away. You will be able to easily appreciate that.
We wanted the other side to begin at 12. We are
I-
now I think we
I-
now start. If we can just formulate, we'll ask the others also to formulate 2 or 3 submissions and then we just.
I bow down, my lord. So if my lords will just briefly consider, then I'll come straight away to the second portion of my submission on 21A, which is the legislative history of the Act. And I'll quickly take your lordship through it. I won't trouble your lords with my note. In fact, the short point is this. In 1850, my lord, the British legislature introduces the Caste Disabilities Removal Act, which says that notwithstanding any loss of caste, excommunication, etc., the laws relating to property and other benefits which flow from customary law will continue to attract to a person. Thereafter, my lords, comes in 1872 the Special Marriage Act. As a result, my lord, as I understand it, of certain demands by Brahmo Samajis who said at that stage that they were not Hindus. And these were live questions, my lord, before the court as to who was included within a Hindu, within the understanding of the term Hindu, and who was not. And therefore, my lord, when the Act came in 1872, since a need was felt, as is felt today, that no community can be without a law of marriage, this statute required that a person give up their religion, surrender their religion, and therefore it's stated, I've set it out in the tables, that table A, my lord, at page 4, that marriage could be celebrated between persons neither of whom profess the Christian or the Jewish or the Hindu or the Mohammedan or the Parsi or the Buddhist religion, etc. So it required me to renounce my religion. Thereafter, my lord, in 1872, in 1923, comes Act 30 of 1923, which amended the provisions both as to who could marry under the Act, and secondly, my lord, as to the restrictions on personal law which applied. So, my lord, if my lord see, the first part was retained, that for certain communities, they still had to give up professing their religion. But now, the underlined portion, that marriages could be conducted between Hindus, the Buddhist, Sikh, Jaina, Hindu, so and so, or between persons, each of whom professes one or the other of the following religions. That is the Hindu, Buddhist, Sikh, or Jain religion. And what we must understand, my lord, is at this time, until the coming into force of the Hindu Marriage Act 1955, this would have been the law for any intercaste marriage. Therefore, my lords, it followed, and I'm cognizant of the time, therefore it followed that, as I've set out in the second table, certain restrictions on the application of personal law were imposed, and at this point in time, it was the most onerous. If my lords will see table B, where I have given the provisions of Act 30 of 1923. Firstly, my lord, in 22, as now, it affects severance from the joint family. Secondly, my lord, the Caste Disabilities Removal Act, my lord. Thirdly, my lord, there were provisions that a man could adopt another son, my lord, in section 26. And my lords, under section 25, no person who adopted under this law would have the right of adoption, who married under this law would have the right of adoption. And under section 24, the Indian Succession Act would apply. Next, my lord, came the Special Marriage Act 1954. And this statute, my lord, is also in 54. We are in the middle of the debates about the Hindu Code Bill. And 1955, the Hindu Marriage Act follows. So now, for the first time, there is a unified civil law for the Hindus. There is a unified civil law of marriage for the first time. And under that law, intercaste marriage and intergotra marriage is now permissible. And therefore, the restrictions which are adopted in the application of personal law are modified to those under 19, 20, and 21, which we have today. In 1976 comes the final Marriage Laws Amendment Act, which brings in the provision of Section 21A, which now exempts those Hindu couples who marry under the statute from the provisions of 19 and 21. What, my lord, does this history tell us? As far as the application of personal law, since it fell from my lords, as far as the application of personal law is concerned, to a couple who marry, who may be LGBTQ, but who marry within their faith, those statutes which are contemplated as applying under Section 21A will continue to apply. That is my submission. Now, what will be the extent of the application? How will those statutes be read? These will be questions, my lord. Courts may hold, my lord, that we are excluded altogether, that there is no provision for the application. But how will those questions arise? In what circumstances, to which persons? Those are, my lords, questions which, as my Lord Justice Bhatt perhaps indicated, will arise on a factual basis with the passage of time in different circumstances. But my submission, my lord, would be this, that per se, in my lord's reading of the Special Marriage Act, Section 21A must continue to apply to Hindu LGBTQ couples. There can be no per se exclusion of Hindu couples who choose to remain within their faith for the matter of who they choose to partner with. In 50 years, I would submit, my lords, this section has not created any major difficulty with respect to its interpretation to opposite sex couples. And my next submission is this: my lords should not presume and pre-anticipate a difficulty which would arise for LGBTQ couples. On the one hand, the union submits that it would play same-sex marriage or LGBTQ marriage would play havoc with personal law. On the other hand, we tell your lordships that we are part of our societies and our communities. Our parents also long for our marriages just as those parents of opposite sex couples. They long to see that day, your lordships. So let us not assume, yes, there are cases, my lords, where a family may oppose a marriage. Those cases exist for opposite sex couples also. And how have your lordships and the union responded? Your lordships have responded by saying, from a series of cases in Lata Singh's onwards, that the state is enjoined to protect such couples. And the union has also risen to the occasion. The police protect such couples, as today they protect us when we approach the courts. And the state also responds by offering, for instance, under the Dr. Ambedkar scheme, under the Ministry of Social Justice and Empowerment, special schemes to promote intercaste marriage. So, my lord, it cannot be presumed, because today we are going through a process of social change, because today we are at the threshold. Neither this court, nor I would humbly submit the state, should presume that there is going to be a certain kind of outcome. They should see their people. It is not only a question of elites, my lord. We receive calls and we hear from young people across this country. From the inception of this case, my lord, I've received calls from people in Hisar, in Surat, in Chhattisgarh. When I asked, which district are you from? They said, which district? We are from Raipur, we are from Rajnandgaon, you name it. Let us not assume any more than we would assume at the outset of embracing any section of our society within the fold of law. Let us welcome them. Let the union welcome us and bless us as it would bless any other married couple, my lords. We seek those blessings. So, my lord, my last submission, therefore, is this, and now I promise I will wrap up, is that when it comes, therefore, after we marry, to the application of laws, the application of laws must be uniform for both same-sex and opposite-sex couples. On the one hand, my lord, there are general civil laws, for example, as fell from my lord the Chief Justice yesterday, of gratuity, pension, inheritance, succession, and so on. And my lords, those laws, the word spouse would be read in, the word husband or wife would be interpreted in a gender-neutral fashion. And my lords, where a person would otherwise nominate their spouse of the opposite gender, today we would be nominated as spouses of the same gender. The other question, my lord, is the question of having children. Now, it fell from my lords, and very rightly, my learned friend, Mr. Vishwanathan, also said that today, perhaps not all couples wish to procreate. Not all couples who marry shall have children, and nor is having children a condition of any law. But my lord, as a couple, as a married couple, having a child is part of the human experience. And it may be something that some also long for. Today, marriage is a gateway for couples to have children as per the legal framework. So under, my lord, the JJ Act, the adoption regulations require that a couple have been married for a certain number of years, that there be a stable marital relationship and so on. This is, my lord, for a couple to adopt. Now, my lord, similarly, under the Surrogacy Act, only married couples may opt for surrogacy with some provisions. And the child who is born of surrogacy is protected under Section 8 in the same way as a child who is born of, let us call it, natural methods or a natural born child. Similarly, my lord, the adoption statutes say that at the moment of adoption, an adopted child, there will be a severance with the biological family, and the adopted child will have all rights and obligations as a biological child does. Now, what is the import of what I'm saying, my lords? There are already couples in this country who have children, LGBTQ couples, and those couples are also before your lordship. In the absence of the recognition of marriage of their parents, what the law does is it renders, just as it renders one partner of the relationship a stranger to the other, it also renders a child a stranger to its parent-in-law. That child has no relationship in law with one of its mothers who may love her equally as a mother in an opposite sex couple, who may do everything from morning to night as a mother does in an opposite sex relationship. But that child, my lord, without the protection of law, without the protection of adoption law, or the provisions of Section 8 of the Surrogacy Act, or similar provisions of the Assisted Reproductive Technologies Act, is rendered a stranger to its parents. That, your lordships have held on numerous occasions, is constitutionally untenable. A child cannot suffer because of the parents belonging to a protected class under Article 15. This is the sum and substance of my submissions, my lord. I'm grateful for a very patient hearing to this side. I'm obliged.
Now,
Your lord.
we now have four remaining counsel, Mr. Raghav Avasthi, Mr. Shivam Singh, Mr. Namit Saxena, and Mr. Manu Srinath. We would request all four of you to now wrap up in 2 minutes or 3
Your Lordship,
minutes.
Ms. Amritananda Chakravarti. Your Lordship, I'm a petitioner just after Ms. Karju.
Yes.
Yeah, I'll just take 10 minutes, Your Lordship. Very brief. I've already given my note, my lords. It's volume 8. It's a brief 1.5-page note, Your Lordship. I've set out my written.
Got your note. If you can just make maybe 1 or 2 points now.
Yes, yes, Your Lordship.
What is the...
Your Lordship, I have challenged certain provisions of the Foreign Marriage Act and the adoption regulations. I'm the only petition that has challenged the adoption regulations for excluding same-gender couples and transgender persons from the institution of adoption, joint adoption specifically. Why have I challenged adoption regulations? Before that, Your Lordship, I just want to say that the petitioners, they have been in a relationship for the last 15 years, and they have married under the Denmark law on 16th of August 2022. So we are a couple who is married under a foreign law, and we are living as a married couple in Germany. And what we want, we are there because of our professional deputation. We don't want to settle abroad. We want to come and settle in India, but we want with our marital status, we want with our joint life that we have built in Germany. So the question on Foreign Marriage Act, I just have one point, Your Lordship. Your Lordship has my note?
Yes. Why don't you formulate it?
Yes. My first submission under the Foreign Marriage Act, Your Lordship, is, if not for my sexual orientation, the petitioners would be able to register their marriage in India under Section 17 of the Foreign Marriage Act. And what is that exclusion, Your Lordship? That is not, if I may respectfully submit, under inclusion, Your Lordship, that is discrimination simpliciter. To exclude a couple on the ground of sexual orientation, that you are treated as a married couple in Germany and in
Is already
yes.
point is 40 years. What is
So that is discrimination simpliciter. My second point on adoption regulations. Your Lordship, I've set out the adoption regulations in my note.
yes.
B. If I may read, Your Lordship.
What's the point on the adoption regulation?
That my point is the adoption regulations go beyond the remit of the Juvenile Justice Act. If I look at Juvenile Justice Act, Your Lordship, the definition of prospective parents in 249 of the JJ Act, it uses the word person or persons. Your Lordship, if you may look at the JJ Act just for 1 second. 249, Your Lordship. My laws, Justice Kaul and Justice Bhatt has it. The JJ Act 249, the definition. If I may read.
Yes, read please.
Prospective adoptive parents means a person or persons eligible to adopt a child as per the provisions of the section 57. Please mark these words, Your Lordship, a person or persons. Now, if I may come to section 57. Your Lordship, please note JJ Act is a secular legislation that has been said by my learned predecessors. This is not, I'm getting into personal laws. This is the only law which we had brought in adoption from the Hindu personal law into a secular legal regime. Your Lordship, if I may read section 57, clause 1. The prospective adoptive parents shall be physically fit, financially sound, mentally alert, and highly motivated to adopt a child for providing a good upbringing to him. Clause 2. This is the relevant clause, Your Lordship. In case of a couple, the consent of both the spouses for the adoption shall be required. Then 3 is a single or divorced person can also adopt, subject to the adoption regulations. 4, single male is not eligible. That's not relevant. I am on 57.2. My first submission, Your Lordship. Marital status of a prospective adoptive parent is not a relevant factor to determine the eligibility of adoptive parents, including for joint adoption, which is my Roman 3 in my note. If we look, as we had seen, the definition of prospective adoptive parents, or section 57.2, where is the word married here? If the parliament wanted to restrict joint adoption only to heterosexual married couples, because married is not just married couple. As of today, as we have seen in the last 2 weeks, it is heterosexual married couples. Which couple can marry under the Indian law at present? If the parliament wanted to restrict joint adoption under the JJ Act section 57, it would have used the word married. But it doesn't. It uses the word couple. It uses the word spouses. Yes, it may be said that as per the Indian law, couple and the spouses is a heterosexual married couple. But that is not what the legislation says. So how can the adoption regulations... Now, if I may read adoption regulations, Your Lordship, Regulation 52A, which I have challenged. Any prospective adoptive parent, it is set out in my note, point B, irrespective of his marital status and whether or not he has his own biological son or daughter, can adopt a child subject to the following, namely A, the consent of both the spouses for the adoption shall be required in case of a married couple. Regulation 5.3, no child shall be given in adoption to a couple unless they have at least 2 years of stable married relationship. Where is this word marriage in the JJ Act, Your Lordship? And even Your Lordship has held, Chief Justice Justice Chandrachud, in X versus Ministry of Health, marriage is not a precondition to the rights of individuals, whether alone or in relation to one another. Your Lordship, I will not take you to the judgment. It is in the common compilation. But I am emphasizing on this phrase in para 40 of the judgment, X versus Ministry of Health. Marriage is not a precondition. So it means even this principle has to be applicable to the point of joint adoption also. Marriage is not a precondition to the rights of individuals, whether alone or in relation to one another. I'm emphasizing in or in relation to one another. Just take the example of the petitioners, Your Lordship. I am a married couple in Denmark. I come to India. My marriage is not recognized. I am dealt as two single individuals who are stranger to law. I cannot even go for joint adoption because of this regulation, which is not borne out from the text of the law. My next submission, Your Lordship, is restricting joint adoption only to heterosexual married couples amounts to discrimination on the ground of sexual orientation. Why am I saying this? Because one can say that, yes, even unmarried heterosexual couples can also not adopt jointly. But they have the option to marry under the Indian law. But a same gender couple or couple involving a transgender person, they do not have the option to marry. So in effect, what the adoption regulation is doing, it is essentially restricting joint adoption only to heterosexual married couples. And that, in my humble submission, is discrimination on the ground of sexual orientation. And I will show Your Lordship from the CARA circular, which is on, if Your Lordship, compilation 2 documents, volume 2, if Your Lordship want to look at it, that is a circular dated 16th of June, 2022. And I will show how that circular even bars me in my individual capacity. That is in compilation 2 documents, PDF, volume 2, PDF 459, sorry. Your Lordship may please look at it. Compilation 2, documents, volume 2, PDF 459. Just one document I want to show Your Lordship. It's a CARA circular dated 16th of June 2022. And that will show the sheer absurdity, because it fell from the Lordship last week that a lesbian woman can adopt in her single capacity. Okay, you might not be able to adopt in your joint capacity, but you can adopt as a single person. Now I will show. Your Lordship has it, the circular? Volume 2 in documents, compilation 2, volume 2, documents, page 459, PDF page 459. Justice Bhatt and Justice Kaul has it?
Yes.
Read it here.
If I may read, just 3 lines. It's an office memorandum from Central Adoption and Resource Authority. Registration of cases of single PAPs, prospective adoptive parents, that is, having a live-in partner in a long-time relationship and not married regarding. It has been noticed from home study reports that some single PAPs registered with CARA for the adoption process are in relationship with their live-in partner. The cases of single PAPs engaged in live-in relationship have been discussed in the steering committee of Central Adoption Resource Authority held on 18th April 2022. It has been decided to go with the earlier decision of 14th, I'm not reading that, then after 10th May 2018, that the cases of single PAP in a live-in relationship with a partner will not be considered eligible to adopt a child, and their registration from concerned agencies, authorities will not be considered for approval. Then point 3, this is the main line. The decision has been taken in line with Regulation 5.3 of the Adoption Regulations 2017, which is exactly the Adoption Regulation of 2022, 5.3. The authority would like the children to be placed only with the stable family, and single applicant in a live-in relationship cannot be considered as stable family. Your Lordship, this is the CARA circular, which is barring even a single person who is in a live-in relationship from being eligible to adopt a child. All this while, we have been thinking that a single person, a single queer person, a single lesbian person can adopt in their single capacity. What is the harm? You have access to adoption. But I don't. And where is this coming from? It is referring to Regulation 5.3. So just look at my state. I am married in Germany. I come to India. I am treated as a stranger in law to each other. And now I cannot even adopt in my single capacity because I am in a relationship with my partner. I am, in fact, a married couple as per foreign law. So as per the Indian law, as per the adoption regulations, I am not even thought fit to be eligible to apply in my single capacity. What is the effect and what is the messaging to the queer community? Your Lordship, my last point. My predecessors have talked about right to found a family. I'm saying right to motherhood. I'm a lesbian couple. I have been desiring to have a child, to adopt a child, as much as I desire to have my relationship recognized. Now, last point, Your Lordship, it is not just the right of a adoptive couple to a family. It is also the right of a child to a family. We are talking of adoption, and as per the JJ Act, who is to be adopted? If we look at Section 56 of this right has been statutorily recognized. If I may read, Your Lordship, Section 56(1), adoption shall be resorted to for ensuring right to family for the orphan, abandoned, and surrendered children. These are the children we are talking, Your Lordship, orphan, abandoned, and surrendered. And they have a right to family, not just under the JJ Act, under the international law also, under Convention on Rights of Child, Article 20. The exclusion of same-gender couples and transgender persons from adoption defeats the very purpose of adoption, defeats the very essence and the object of adoption, which is what? Which is to provide a stable, a loving and affectionate family to a child. Just because I am part of a same-gender couple, just because of my sexual orientation, I will be denied this basic right, not just to myself, but even to a child who needs a loving family. And lastly, what Ms. Karju said, Your Lordship, the entire JJ Act, what is the guidance of this JJ Act? It is in the best interest of the child. Is it in the best interest of a child not to have a legal relationship with the second parent? Is this how we are going to advance the object and the purpose of the JJ Act? I rest my case, Your Lordship, with just last point that the petitioners, they are part of a historically oppressed and discriminated minority. Their relationship and their family deserve as much dignity and recognition as it is to be accorded to an opposite sex couple. I'm really grateful, Your Lordship. I'm really grateful.
Now,
Please, this honorable court, Your Lordship, and your ladyship. Yes. My lord, I'm appearing through video conferencing, and as a matter of fact, I happen to be in Germany, and my marriage was also registered in Denmark. My petition is in relation to, it seeks a declaration in relation to Section 5 of the Hindu Marriage Act, and it has already fallen from your lords that there will be no interference with personal law, but let me at least make an elevator pitch because I have only 5 minutes either which way. So I cannot expend more than 5 minutes of the Constitution bench.
But Mr. Awasthi, I think this area we have, nobody has opened. So, for us to open it in 5 minutes would be unfair because, this is an area which we have scrupulously excluded from the scope of the debate. Once we open this up in 5 minutes, it would be unfair, having regard to the canvas of the matter. And nobody else, everybody else would like to then argue the same point, I think.
My lord, I bow down. As a matter of fact, just one moment, my lord, then I leave it up to this bench. My submission only is that as per Section 4, as far as the matters with respect to which provision is made under the Hindu Marriage Act is concerned, there is no interference of any customary religious authority. And my second point is that as per Section 7 of the Act, there is no religious ceremony mandated as such. So if we were to say that if I were to be a straight, should there be a straight couple, then what we are saying is that their faith in the ceremony that they want to adopt would be enough to get their marriage to be valid under the Hindu Marriage Act, while not extending the same courtesy to a same-sex couple. So this is my submission, my lord, and to my mind, it is a violation of Article 14 of the Constitution. And because as I mentioned, as per the Act,
I think we'll leave it at that because I think we shouldn't really explore this any further. I think because this is now out of tune with what is the general line of submissions, the area which has been opened before the court. I think we'll leave it at that for the present, I think.
My lord, much obliged.
Thank you. Now, the next counsel would be Mr. Shivam Singh.
Yes, Your Lordships. Extremely grateful for the opportunity to address Your Lordships. I'll restrict my submissions in 5 minutes. My argument relates mostly to the idea of innateness, and I'll build upon the proposition which has been culled out in para 278.7 of the Navtej Johar judgment, Your Lordships. The argument about innateness, and this has briefly been alluded to by my predecessors, particularly Dr. Singhvi, is that if something is so innate to a person, then it is impermissible and, for that matter, even unconstitutional for the state to utilize that as an opportunity and as a yardstick to impose and discriminate against the person. Sexual orientation is one such category, as has been recognized in the cited paragraph of Navtej Johar. Your Lordship, in this regard, let me just build this by an example. When a person is born, that person, while growing up, will either choose to be right-handed or will choose to be left-handed. Subsequently, through a process of choice, that person can even change whether to be right-handed or left-handed. A person can be ambidextrous. These are the spectrum when we are talking about gender and sexuality. A person can move from one to the other, can be both, can be none. So these are the parameters on which this moves. Now, sexual orientation and gender, as has been recognized in the cited paragraph, is such an innate characteristic of a person that to discriminate on the basis of that would fall the test of constitutionality. And I say this for a particular reason, Your Lordships. It is not open for the state government to discriminate, or for that matter, the union government to discriminate on these parameters. If they were to do so by using a person's sexual orientation against them, something in most cases people have no control over, then without establishing as to what is the harm which is being caused to any other person, it would fall foul on first principles with the social harm, Your Lordships. There is no harm which is being caused to anyone in this regard.
From that, what is the submission?
Your Lordship, the continuation of this is that the grant and conferral of these positive rights upon the queer community is not a zero-sum game. It is not being granted to the queer community at the expense of anybody else on the other side. The only argument which the union, or for that matter, the state government can present is that this is running contrary to the idea of social morality, of public morality, and that is the basis for them to deny this right and to deny this privilege. In this regard, Your Lordships, let me just build the argument as to why it would be completely impermissible to do it. Their argument about social morality and public morality rests in an amorphous contour which they are yet to define through their counter affidavit. Their counter affidavit, however, proceeds on a slightly hurtful, if I may say so, presumption, which is available in para 36 at page 45 of their counter affidavit, wherein they say that only one form of protection, or only the highest form of protection, is available to marriages of the opposite sex. Merely because that has been the case so far is no reason for the union government today to argue that it must also be the case going forward. They have to demonstrate as to how the conferral of these rights would dilute or snatch away the already vested rights. And Your Lordships, in continuation of this, I would just, as a matter of abundant caution, Your Lordships have already indicated on day 2 that probably this is not an argument to belabor upon. On the concurrent list aspect, this is a part of entry 5, Your Lordships. Previous hearings have indicated that whether hearings have taken place on arbitration entry 13 or IBC entry 9, it is not a case where all state governments must mandatorily first formally be issued notice and then they come. State governments are already here. The union has already invited them. They'll assist Your Lordships. The law which Your Lordships will lay down under 141, one way or the other, whether for us or against us, will be binding upon them in terms of the meaning of Article 144. So it will not be open to them to say that merely because we were not formally impleaded as parties, we will escape the rigors of this law one way or the other. And to conclude, Your Lordships, I'll just make this submission. Your Lordships, it is part of the basic structure that secularism in India has progressed and thrived and endured because it is founded on the concept of Sarv Dharm Sambhav. Your Lordship, through the building blocks of Navtej Johar, Joseph Shine, Babita Punya, and now Supriya Chakravarti, it is time for the concept of Indian marriages to endure by embracing the concept of Sarva Linga Sambhav. I'm extremely grateful for a patient hearing.
Thank you, Mr. Shivam. Mr. Namit Saxena.
Mr. Saxena is not available. He's not well today. So we have submitted a one-page
All right, we'll look
let
at
that be
this.
done.
Yes, Mr. Manu Srinath.
Well, I have prepared a one-page formulation. If I could just hand over, I would
Yes, sure.
mail the soft copy.
So this is the one.
There are four major contentions, my lord, which I have taken. I would not repeat these arguments orally. The judgments as well as the paragraphs which I am referring to are mentioned there. The written submissions, my lord, would find it at page number 605 of the compilation 1. Those arguments are dealt with extensively. So I would not repeat these arguments again here orally. My lord may consider my written submissions. The four major the arguments taken, my lord, are that exercise of judicial review would become a duty for this constitutional court and would also become a matter of entitlement for persons when fundamental rights are violated. That it is the court's duty to do an organic construction of ordinary laws of the land as well as that of the constitution. And the exercise of judicial review to achieve social justice should also be there. Finally, my lord, the exercise of judicial review leading to an increase in size of the intended pool of beneficiaries of a statute, my lord, is permissible, and such an exercise will not amount to legislation by courts. I've cited the examples of Geeta Hariharan, D.S. Nakara, my lord, as well as Secretary Mahatma Gandhi Mission, which is 2017 SAC.
All right. Thank you. Thank you so much. Brother Call, should we take just a 5-minute break? That will also give the, then we can start with the submissions of the Solicitor General.
My lord, there are 3 interveners in the matter. And in my case, my lord, it's a very practical point that I wish to highlight. My case is that of a trans woman who converted to a woman after undergoing sexual reassignment surgery. Now, this is a woman who has all her life lived and dressed like a woman. She's part of the Bollywood industry as well, my lords. After undergoing sex reassignment surgery, she married a male, a biological male, my lords, under Hindu rites and ceremonies. Thereafter, my lords, she has registered her marriage under SMA. All this has happened before the Transgender Persons Act came into force under the strength of NALSA, my lords. There are 3 or 4 litigations which are pending between her and her husband right now, including one litigation under Domestic Violence Act. There is one FIR under 498A 406. There is a suit pending for dissolution of marriage under Section 13 HMA. My lords, there is one submission that I want to make, rather, in fact, 2 very short submissions here, because I believe that the judgment of this Honorable Court may directly have an impact on my ongoing litigations, my lords. My lords, HMA per se does not prohibit these kind of marriages, my lords. It neither renders this kind of marriage void nor voidable. And I'll quickly demonstrate that by reference to Section 5, my lords. If my lords could quickly have that, my lords.
Which act? Hindu Marriage Act.
Hindu Marriage Act, my lords.
Counsel, there is one concern here.
I don't think we'll go into this at all because if consistently said.
My lords, I understand, but this is a case of not of same-sex marriage, my lord. This is a case where she has undergone the sex reassignment surgery.
Deal with individual cases like this, because otherwise there will be infinite variations in individual cases.
My lords, the practical difficulty here is that
ultimately that's why you are an intervener. We can't now sit down and look at interveners' facts and deciding a wider issue of constitutional jurisdiction.
My lords, I completely appreciate that. But my lord, just for a moment, if I could point out the contravention of Section 5(1) subclause 3,
See, this
which is
all going to be case specific. And if we get into specifics of each case, then there's a Pandora box that'll open up. We can't go that.
Then, my lords, what I may submit, I'm not referring to personal law. Let me submit this. As per the Transgender Persons Act, now there are 2 categories which are recognized by the Act itself. One is a transgender person. The recognition given under law is that of transgender person. The second category under Section 7, my lords, is that of recognition as male or female. Now, once I've undergone the sex reassignment surgery, or those persons who may be called as transformed gender persons, my lords, because now they are conforming to the biological yardstick as well. So they may be entitled to equal protection under the law.
Right,
so that impact,
yes,
my lord, may
Gupta,
consider while passing the judgment.
Gupta,
yes, Lord, 7 minutes, I will be less than that. My lord, I appear for, my lord, the queer collective of, my lord, the Indian Institute of Science, which is a protective body, my lord. Now, we have, my lord, our submissions are in volume 9 of your lordship's, my lord, compilations. And, my lord, a 1-page note has been emailed today, my lord. You have copies? My lord, I can hand up 3 copies if your lordship so pleases now. I will only, my lord, address your lordship on 5 issues and I'll just state them. I won't argue. My lord, I have thought about this matter, my lord, on the basis of 2 questions: why and how. Why it is to be done and how it can be done. My lord, most of the submissions, 4 of these are, my lord, points on the issue of why. My lord, first of all, my lord, Section 4C of the Special Marriage Act appears to make a distinction between men and women as far as age is concerned. But this is no longer, my lord, a policy consideration, because, my lord, pursuant to your lordship's judgment in independent thought, the Child Marriage Bill has already been tabled, which, my lord, seeks to equalize the marriage age for men and women. So, my lord, there is a consensus that on the appropriate age of marriage. So the difference between these 2 categories, my lord, in the section is not a matter which should come in the way. That's number 1. Number 2, and this is very important, my lord, that persons of this, my lord, sexual orientation are being forced into marriages. And what is worse, my lord, heterosexual marriages. And what is worse, my lord, there are unscrupulous people out there who are suggesting that there can be conversion therapies, that it is medically capable of being corrected. Now, my lord, it has gone to such an extent, my lord, and I have got, my lord, a 1-page, my lord, opinion of the Indian Association of Clinical Psychologists, which I am handing up, my lord, where they have said that please do not get into, my lord, this question of conversion therapies. My lord, the point being, my lord, that if they are permitted to marry, they will be protected, my lord, against any forced marriages of the heterosexual nature, and they will not be subjected to any conversion therapies, my lord. So this is, my lord, a reason why. Thirdly, my lord, it is a misconception to say that family values that Indians cherish will be affected. Because, my lord, it is precisely for those so that they may enjoy and practice those family values that they wish to get married. All the values which we cherish as being, my lord, family values are, my lord, going to come into effect if they are permitted to marry, my lord. That's the third thing. The fourth aspect, my lord, is, of course, your lordship has heard it at length, and that is, my lord, that it is discriminatory per se to have a legislation which makes a distinction. Now, on that, my lord, in my note, and I'm not troubling your lordships further, paragraph 20 refers to, my lord, 2 judgments, one of South Africa and the other is of Canada, which says so, my lord, that if there is a legislation of relating to marriage and that legislation is discriminatory in the sense that it leaves out same-sex marriages, then I'm sorry, my lord, if it leaves out same-sex marriages, then it is discriminatory. Now, my lord, I come to the 5th aspect, my lord, that if the question of why is answered in favor of the petitioners, in that event, my lord, in order to prevent the invalidation of the legislation, my lord, it would be necessary to read it purposively. And, my lord, your lordships have already said that could involve adding, omitting, or substituting words, and that is AFCON's, my lord. My lord, those are my submissions.
Thank you, Mr. Gupta.
I just need 1 minute.
May it please the court, my lord, I think I come next in the order of the sequence that is given to your lordships. If the sequence is being followed.
It is to address the
Tulsi Raj, Ms. Tulsi Raj.
Yes, I'm, yes.
Please.
Also,
Obliged. I've prepared a brief note, my lord. I'll hand over a copy. Without repeating any of the points that's been already made, my lords, I think only 2 aspects of anti-discrimination theory that remained unexplored so far in the debates. The first aspect is, my lord, the concept of demeaning, which has been conceptualized by the scholar Deborah Hellman, and which your lordships will find on pages 3297 of volume 4 of the compilation on behalf of the petitioners. Ms. Hellman explains that every case of demeaning, my lords, every case of disrespect does not constitute wrongful discrimination. Scholars, my lord, your lordships are well aware, have always asked the question of what is in fact necessary in law for some act to be constituted wrongful discrimination. And she identifies two elements as important for an act to be identified as wrongful discrimination. The first is, my lord, that there should be an expression of unequal humanity of the other, that there should be an action that reflects that the other person is not treated as an equal moral person, and that is the first requirement. The second is that, my lord, the person who is discriminating, the discriminator, should be able to do that because of the social context. That is why, my lord, your lordships are aware, we have the whole concept of cognate and dominant groups in discrimination law, and it's always conceived that it is always a dominant group who is able to, or who is conceived by law to be able to discriminate against a cognate group because of the particular social context. Now, in this case, I would submit, my lord, that the exclusion of LGBTQ persons from the ambit of the Special Marriage Act would constitute demeaning in the way that scholar Hellman explains it. This is because, my lord, there cannot be a better example of demeaning rather than to say, my lord, that your love is incapable of being recognized by the law. There is no, my lord, no better example of demeaning rather than to say that your partnership is not deserving of legal recognition. Therefore, my lord, I would submit that the scholarly understanding of discrimination law, my lord, might help us to inform the reading of Articles 14 and 15, to inform our reading of the Equality Code of the Constitution. Now, the next point, my lord, is by referring to the theory of disgust by Martha Nussbaum, and your lordships have extensively made use of the scholarly literature by Nussbaum in various judgments. Now, my lord, the theory of disgust is propounded in the way that the approach towards same-sex couples or the approach towards LGBTQ in toto is grounded on a public disapproval, is grounded on certain prejudicial understandings of how these couples or how these persons conduct their lives. Now, your lordships will certainly appreciate, my lord, that the history of this is tracked, in fact, by Nussbaum in the American context by collecting statistical data relating to pamphlets which were spread during the whole debate on.
We'll have a look at that.
Yes, my lord.
Be circulated. Then your next point is expressive harm and discrimination, which is based on Joseph Shine.
Which is based on Joseph Shine, my lord. I just want to make the point there, my lord, that when your lordships, my lord, struck down section 497 of the IPC, my lord, there was nothing in the provision expressly as it stood, my lord, which expressed any opinion about how what it conceives about the sexuality of women. But your lordships went ahead and said that there are certain prejudicial notions which inform this provision, and that is sufficient, and that prejudice is sufficient to render this provision unconstitutional.
The next point is about the proportionality test, which has been argued actually. We have just yesterday it was cited.
Yes, my lord, the proportionality.
That's all right. You cited modern day.
Yes, my lord, your lordships have dealt with proportionality, my lord. And
then fourth is that your case is supported by data and that the respondents is.
Yes, no, because, my lord, in paragraph 18 of the counter affidavit, my lord, the union says that there are psychological harms which are caused to the children of LGBT. That, my lord, is in fact rebutted continuously by data, my lord, and I have referred to one study, that is a British Medical Journal study on pages 3341 and 3358.
You are advocating a moderate interpretation, reading A as the in the SMA.
Yes, my lord. That is, in fact, a lot of suggestions have been put forward before your lordships, my lord, and it is, of course, up to your lords as to which interpretation will be taken, and that's a moderate and a minimally invasive provision.
Thank you.
I'm obliged.
My lords, if I may, I only wish to address.
What's your name?
My name is Tanushri Balla. I'm an intervener.
Tanushri Balla. Tanushri Balla. Yes.
Sir, I only request to address the 4 questions placed by this honorable court before the petitioners.
Yes.
Your permission, please. Sir, I've submitted my written submissions and a brief note. If I may hand the same over to the bar, please. The bar, please.
So we also look at this. It's being given physically to the.
Yes.
Yes,
my lord. Sir, the first question, your lordship, the first question addressed was on section 2B as to the reading of the terms man and woman. my only request is that it may be considered that there is also gender expression amongst parties who are seeking this kind of validation. There is gender expression, and then there is also the question of roles that may be assumed by parties to such marriage. If this concept, read in light of Arun Kumar and certain other data which I have put on record in my main IA, be taken into consideration, my laws, we may see that basically the problem in all the other sections remains solved. My humble suggestions are, my laws, that the man in 2B be read to include all three, that is both cisgendered and transgendered men, as well as any person who assumes a role in the marriage that this statute confers upon men. And similarly for women, all three, that is cisgendered, transgendered, and any person of either sex or gender assuming the role of a woman or a wife in that particular relationship may be conferred upon by the statute or by the society or by the institution of marriage. This will also remove the difficulty for trans persons, intersex persons who are not included in this ambit seeking to enter the institution of marriage laws. Accordingly, lists of prohibited relationships in Part 1 and Part 2 may be read to include any person, whether cis, trans, or otherwise, including but not limited to those identifying as third gender, so that both lists may apply uniformly and the difficulty with related to degrees of prohibited relationships may be removed. Thirdly, my lords may be pleased to direct the government to declare LGBTQI, which has already been done for the trans community, as a special class, as they are allowed to do so for customs, so that where personal customs of parties allow them to get married and enter such institution, there may be no difficulty for them to do so. We are not touching upon personal customs, but where they are allowed by personal customs, where families are supportive, they should not be hindered just on basis of a technicality. My second point, with your permission, is Section 4C, which was the consequence of Section 2B, as pointed out by Honorable Justice Bhatt, that it has already been pointed out by learned senior Vishwanathan sir that the section may confer 2 males and 2 females of age 21 and 18 respectively to enter matrimony. However, what I request to add, sir, is that this provision leaves out third gender persons who may be intersex persons and who may be left out of the binary of male and female. For that, I request, my lords, kindly read an age into the section for third gender persons not conforming to either male, female, or the role of a man or woman based on self-identification, such as intersex persons. So, and also any other affected person on the remaining spectrum may be addressed by this particular reading. And this may also be relied upon Section 15D of the Act, Malos, where the age is uniform for any parties as 21 seeking to register their marriage within the Act, without leaving any lacuna for external controversy or any external violations. Malos, my next point, which is extremely important and which I request to add before this honorable court, is based on Section 24(2). My lords, this is the section for void marriages on grounds of impotence. Now, in practical cases, it has been seen that unscrupulous people enter into such marriage with trans persons, and when disputes arise, as in the case of intervener Bobby Darling, they seek the shelter of law, stating that the marriage was void ab initio because of the ground of impotence, or that they did not know. Herein, if my lords may please to declare or add as an explanation in any way that these marriages would be void except when knowledge of such impotence was communicated prior to the marriage to both the parties by either a visibly obvious way or in an express manner, basically prior to the marriage, or where the parties, after discovery of such fact, have continued to cohabit, condone, and live with each other in harmony for at least 1 year after the discovery, then this particular law, which is being misused by unscrupulous persons, can be addressed, and this will greatly reduce litigation, Malos, current litigation.
All right.
And Malos, lastly, I will just conclude in under 1 minute. If we read gender expressions and accept the roles assumed by parties into this act during interpretation and harmonious interpretation, Malos, all the remaining sections and all the remaining difficulties will stand resolved as in third, fourth, and fifth schedules. It's on para 6 of my brief notes, my lords, wherein declaration may be by either two brides or wives, or two bridegrooms or husbands, or a bride and a bridegroom of either biological sex expressing or assuming the role as per the marriage. Sections 12, 22, and 27, where it mentions either husband or wife, it does not mandate.
All right, we'll have a look at
That's,
it. Thank you.
Thank you, my
Thank
lords.
you very much. We'll rise, I think, now because we have just 5 minutes. Mr. Solicitor, we'll hear you after lunch.
Look, there was a matter, but wherein 80/3 had said that she may join.
That's it. Brother Call, Brother Bhatt.
Yes.
Justice Call is on the screen, Malad.
Brother Call is joining. Yes, Justice Bhatt is
Bhatt is
also on the
also.
screen. Yes, Mr. Solicitor.
Wait, please, Lord. Look, the real question, Lord, before I come to the real question, Malad, as I started, Malad, not only as a law officer, but even as an advocate, as an officer of the court, or even as a citizen, your lordships are dealing with a very, very complex subject, having a very, very profound social impact. I would earnestly reiterate my request, my lord, if your lordships can consider leaving all these questions to Parliament for the reason, my lords, that your lordships have read right to choose the sexual orientation in Nautet Johar, and there is no dispute about it. Your lordships have said that based on one's sexual orientation, there cannot be any discrimination. There cannot be any dispute about it. Right of personal autonomy, namely right of choice, is also recognized by your lordships in Nautaj. Therefore, my lord, the question is, Lord, now what is the prayer before your lordship is right to get the socio-legal recognition of marriage. Lord, the question so far argued was what constitutes marriage and between whom marriage can be constituted. The real question is who would take a call as to what constitutes marriage between a particular class of people. Well, that takes me to my first respectful submission, and my lords were very kind enough to say.
What did you say? Who would take the call on?
What constitutes marriage and between whom? Therefore, my lords, when I made the first request, my lords were very kind enough to say that let us have the canvas, let us have a broad conspectus of what their arguments are, and thereafter we'll take a call. Your lordships were pleased not to reject that, my lords. So, my lord, I am reiterating that request. It's my appeal to your lordships, my lord. But there are several ramifications, not only, my lord, on the society, several ramifications, unintended ramifications on other statutes, which would need, Lord, a debate in the society, debate in various state legislatures, debate in civil society groups. So, my lord, at the outset, my lord, I say, my lord, your lordships can consider saving the rest of the exercise if your lordships, my lord, are convinced that this has to be preceded by some debate, particularly when the debates would take place in a forum where there would be assistance of national views, views of experts, views of impacts, views of effects it will have, and what are the implications on several laws. Lord, I have provided the list of about 160 sections from various provisions of law, other than, my lord, Special Marriage Act or law relating to marriage, where it cannot be reconciled with what is sought to be prayed, my lord. Another thing, my lord. your lordships have the legislative policy so far. The legislative policy has always been in all the laws, my lord, which your lordships have come across on several occasions, has been to recognize conventional man and conventional woman. I understand difference between gender and sex, sexuality and gender, etc. We are not going into it. But all laws, my lord, whether it is criminal law, civil law, any other law, law giving protection to women, etc., they define the man and woman in the conventional sense. When this question is being debated before your lordships for the first time, I'm posing a question to myself, and my lord, based on that, appealing to your lordships, should it not go first to the parliament or the state legislature? No one is sitting on value judgment whether this should be, this is good, this is bad, this should be done, this should not be done. There is no stigma attached. The parliament has accepted their right of choice, their right of sexual preference, their right of autonomy, and that right of privacy.
Right of choice?
Autonomy, sexual autonomy in terms of sexual preference, and the privacy, that is right of intimate relationships, which your lordship said, my lord, something happening between two consenting adults in privacy. Why I say, my lord, that there is no stigma. The legislative policy is very clear now in the Transgender Act, where the term transgender is very widely defined to include, my lord, all shades and all spectrums of what we call LGBTQ+. The Transgender Act is the response of the Parliament, my lord, in view of Navtej Johar, my lord, and other judgments, my lord. There are specific provisions where discrimination is prohibited and it's criminalized. I'll take your lordships to the, my lord, scheme and architecture of the Transgender Act. There's no stigma. The limited question is whether right to marry can be prayed for as a social institution by way of a judicial adjudication before this honorable court. The right to marry does not include right to compel the state to create a new definition of marriage. Parliament can do. But it's not an absolute right. Now, my lord, kindly consider when your lord, therefore, my lord, again at the cost of repetition, my appeal to your lordship is, my lord, that rather than, my lord, taking this matter any further, if your lordships are convinced that this is possibly a subject which may better, my lord, be left to the choice of the parliament, which is the law, my lord. If need be, I'll assist your lordship with that law. And the subject is such that your lordships may not be in a position to conceive of variety of situations which may arise and which will have to be taken care of. Lord, mere declaration that they have a right would be, my lord, begging the question. If they have a right, how the rights would be regulated? How variety of problems will be solved? And I'll give examples, my lord, which only parliament can take care of. Now, my lord, kindly consider, my lord, pre-56, marriages used to take place between heterosexual persons, my lord. Conventional societal acceptance. Correct, my lords? Once it gains societal acceptance, in Hindus at least, it came to be codified in 1956 by way of a Hindu Marriage Act. For other religions, by and large, it remains uncodified. Marriage between heterosexual, same religion persons. I am on the concept of marriage, the social status which it gets. Now, my lord, the moment any right which was pre-existing even without recognition by law is recognized, it is also regulated. And then there is no absolute right to marry even today between heterosexual couples. And why I say this? A man has to be 21 years and a woman has to be 18 years, meaning thereby the law prescribes when to marry. The autonomy goes. Bigamy is prohibited. So law prescribes how many times you can marry simultaneously till your wife is or husband is alive. There are prohibitions regarding degrees of prohibited relationships, meaning thereby law regulates whom not to marry. Once the law recognizes this socio-legal institution as a marriage, you just can't walk out of that institution. Law regulates even that on what grounds you can have judicial separation and on what ground you can have divorce. So how to separate is also a legislatively regulated provision. So coming to the privacy part, even the codified law amongst heterosexuals protect the privacy of man and a woman inside the bedroom. But there are certain provisions where there is an intrusion to privacy rights also. For example, importance is a ground for divorce. That is something very, very private and personal between the two human beings. But then, if it is a case of divorce, you will have to come out and prove it. So your privacy is breached. The substance of my submission, which I will elaborate, is that once a legislative recognition is given to a particular form of union, it comes with it several regulatory provisions And it is only the Parliament, my lord, which can conceive of several situations which would arise in this relationship which is now recognized and can provide for its regulation. It would be impossible for the court to conceive all situations. Now, my lord, my propositions, my lord. I'll just, my lord, my lord, there are 10 propositions, my lord. My lord, the very heart of Special Marriage Act, and I'll show that, is a recognition of marriage between a conventional man and a conventional woman. Your lordships need not, Lord, write, because I have, Lord, in that page 3, my lord, I have, my lord, written them. Second, the request, my lord, and I will demonstrate, my lord, more effectively. The request ultimately is that you please rewrite to suit our situation, which can be done by the Parliament. I am not, my lord, opposed to the situation or some regulation coming into place. By whom is the question? And that rewriting would not be possible Lord, this also, your lordships need not, my lord, invest, my lord, time or energy, my lord, in writing it. This rewriting is not permissible, not only on the ground that the courts would not rewrite the law or say what the law should have been, but the thing which we are now seeking to achieve, the petitioners are seeking to achieve, was consciously omitted in Special Marriage Act. That is one more reason it cannot be read into it. I'll, my lord, make that submission good. So, my lord, your lordship's exercise would be constrained, my lord, by 4 fundamental principles. One, the court will not change the character of the law. And the character, your lordship, will have to examine from the entire architecture of the act, read with all allied statutes and the history which preceded enactment of the Special Marriage Act. Second constraint would be the court cannot substitute the legislative intent which is otherwise manifest. And third, your lordships will not, my lord, read words of larger amplitude in place of words of smaller amplitude, namely, person is a word of larger amplitude in place of male and female. Next, my lord, proposition. Lord, this exercise, even if your lordships are persuaded to undertake, would necessarily have an unintended impact on the heterosexual couples, because Special Marriage Act essentially is for regulating the marriages between intra-faith heterosexual couples. Now, I'm sorry. Next proposition is, your lordships would not, my lord, undertake an exercise whereby the same statute is applicable differently to one class of persons and totally differently to another class of persons, namely heterosexuals and non-heterosexuals.
Where the same statute is applicable?
Differently to different classes of
So we
persons,
use,
my lord, namely heterosexuals and non-heterosexuals.
we use one lens for heterosexual couples and another lens for non-heterosexual couples.
Yes, my lord. And I'm grateful, my lord. I could not put it that succinctly, my lord, but that's the respectful submission. And it would be impossible for your lordships to reconcile this classification. I'll be able to show from the scheme and structure of the Special Marriage Act. Next, my lord. Lord, we are dealing with, let us understand what we are dealing with. Lord, we say LGBTQAI plus. Correct, my lords? We know L stands for lesbians, G for gays, B for bisexuals, T for transgenders, Q for queers, I for intersex, A for asexual. Look, we have not tried to know what plus means. And my lord, this is going to be the core of the problem which your lordship would face if the judiciary were to take over the function of regulating the relationship after recognizing it as a socio-legal relationship. Lord, there are 72 shades or variations. That is why, my lord, what we write is plus. And please examine, my lord, how your lordships would, even if your lordships are persuaded to, my lord, kind of undertake an exercise of rewriting, my lord, deal with these varieties of situations. My lord, please allow me to place, my lord, that, my lord, at page. I'll just, my lord, give some examples to, my lord, annexure A, page 109.
Of what, Mr. Solicitor?
My lord, of my written submissions, my lord.
Just go.
Lord, my Lord Justice Paul, my Lord, has my written submission.
Yes, yes.
There are several different shades and spectrums, my Lord. It's not that we are dealing with either lesbians and gays and transgenders. We are dealing with, my Lord, it is note 1, submissions on the question that only legislature can deal with the subject matter. I'll just, my Lord, give some examples. I'm not going to read all 72 categories. Lord, can I, for ready reference, my Lord, give the physical copy?
No.
Which page you said, Mr. Solicitor?
Referring to written
Nothing of the kind. In fact, your physical copies, please send them away back to your office.
PDF 113, my lord. I'm sorry, my lord. It was a loose ball. I forgot that I am also using a physical copy, and your lordship's continuing mandamus is being breached, my lord. Kindly pardon me, my lord. For
Threat is that they're going to be confiscated.
Yes, my lord. I will be, my lord, on.
There are this Union of India submissions. Volume did you say, solicitor? Volume?
Note 1.
Yes.
Written submissions, note 1, only the legislature can deal with the subject matter. Is that
That's
what
the
you
title, my lord.
Yes.
Submissions on the question.
This one. Other related
folder.
Opening statement.
Union of India folder.
Page
Yes.
note 1.
Page 113 is other related.
Got it.
Note 1. Only the legislature has the power.
Paul is leading us. That's very nice.
Yes.
The PDF number 113?
Yes, PDF 113.
Where all these definitions are given.
Yes. My lord, kindly, my lord, now visualize your lordships were to give recognition to LGBTQ+, which is an unidentified class of persons, and there are at least 160 statutory provisions in different statutes. How, my lord, we will be able to reconcile with this, my lord, different spectrums and shades? Please see first, agender. A person who does not, your lordship gets, my lord the Chief Justice, your ladyship gets, my lord. A person who does not identify themselves with or experience any gender. A gender person are also called null gender, genderless, gender void, or gender neutral. Please see 3. I'm just giving my lord a flavor, my lord, that it's impossible to reconcile by in a judgment. My lord, even Parliament will have to undertake a humongous exercise if the Parliament as a policy decides to recognize the marriage. A gender that is indefinable or indomitable, people identifying with this gender refuse to be categorized in any particular gender identity. So whether they are men or women, which provision of which law which governs either man or woman, Lord, will be a big question. Then 4, also called avious gender, this gender identified changes according to one's surroundings. This is kind of a fluid. There is nothing not specific. Then 6, this is based on the person's mood swings or fluctuations. So a person can be having, my lord, male sexuality for some time and a female sexuality for some time. And say at the time of divorce, if a lordships were to read person and they get the recognition of marriage under the Special Marriage Act, Lord, what would be their gender when we test, my lord, the grounds of divorce?
What is the source of this table, Mr. Solicitor?
My lord, this is, my lord, I don't think, my lord, it is. There are various sources, my lord, but essentially from.
Must be taken from somewhere, some glossary or something like that.
Medicine net.
Turn to the previous page. It gives you the footnote. Courses, medicine.
But my lord, I have checked up from 2-3 sources. This list is consistent.
Yes, yeah, you have given in your footnote 45.
In the footnote, yes, my lord, I have given medicinenet.com.
On page 108, footnote 45 at the heading, source medicine net.
Footnote 43, my lord. 45.
The others, 72 others.
Then, my lords, 8. Alexi gender, the person has a fluid gender identity between more than one type of gender, although they cannot name the genders they feel fluid in. Then the gender identity stands apart from existing social gender constructs. It means having a strong specific gender identity that is neither male nor female. My lord, transgender, my lord, is different. Transgender, my lord, is conventionally, as we know, is different. Now defined to mean everything, my lord. But transgender means, my lord, the person who has sexual genitals other than what, my lord, he is supposed to be born with. Lord, then amara gender, having a gender identity that changes depending on the person one is emotionally attached to. If a person is emotionally attached to a man, then he has a male sexuality. If woman, then he has a feminine sexuality. Then embonic. The person identifies themselves as both man and woman and yet does not belong to either. Therefore, I repeatedly say this is an unidentifiable class we are dealing with. Then amica gender, a gender fluid identity where a person changes their gender depending on the friends they have. It's also called, my lord, by some as pure gender, my lord. My lord, 17, my lord. Anogender. The gender identity fades in and out in intensity, but always comes back to the same gender feeling. So at particular act, he has one gender identity, then it changes, it comes back. These are not facts I'm giving. I'm without having any value judgment. The only limited purpose of showing is that would it be prudent or possible for the court to lay down, my lord, regulations, even if your lordships are persuaded to confer them with the socio-legal status of marriage. Because then regulating it would be impossible, because there would be 101 contingencies, which my lord, with best of the assistance on our side, your lordships, my lord, cannot conceive of. Then, my lord, kindly turn the page. Lord, 27, exigender, a gender identity that is between the two extremes of agender and any other type of gender. Both the genders are experienced one at a time without any overlapping. The two genders are described as on the opposite ends of an axis. And bigender, having two gender identities at the same or different times. Then 30, blur gender, also called gender fuss. Blur gender means having more than one gender identities that blur into each other so that no particular type of gender identity is clear, etc., my lord, etc. I'm not giving examples, my lord. Now, my lord, your lordships are necessarily dealing with an unidentifiable class. Now, please come to, my lord, page 16 of my written submissions. Lord, would it be prudent or legally permissible, my lord, to deal with this subject, my lord, on the judicial side? Your lordships are not examining a prohibition against marriage. My lord, kindly bear this distinction is mine. There is no prohibition amongst LGBTQ plus community to marry. Your lordships are not examining the validity. Your lordships are being requested to confer a legal status of marriage which all religion considers to be an institution. I'm not on the morality of it, though that would be a valid consideration. Lord, page 4 to 15, I have given, my lord, what is the institution of marriage in the Indian context? In case of Hindus, what the Hindu scriptures say. In case of Muslims, what Holy Quran says. In case of Christians, what Holy Bible says. It's a social institution conferred with the legal status. And all these social institutions are predating the statutes and have accepted marriage as an institution only between heterosexual couples. And again, my lord, we are not sitting in judgment over that decision. That's what the society has accepted since millions of years.
Sulista, where are you referring to on this aspect?
Lord, page 4 to 15
of
my submissions, my lord. Page 6 to 15, I'm sorry.
Actually,
Even my lords,
your formulation is best brought out in page 11.
Yes, my lord.
44.
Yes, my lord.
Those 4 points.
Lord, may I just read, my lord, for your, my lord, so that I make myself more clear. The world religions have shaped the history of marriage and family and continue to form the basis of marriage as an essentially religious concept. While it is correct that there is significant divergence between different faiths and their practices in relation to marriage, what must not be lost sight of is that there is more convergence than conflict in teachings of marriage and family. All six major world religions overlap on the following attributes of marriage as identity. Then I have given the source. First, each of these religious traditions confirms marriage as a vital and valuable institution and practice that lies at the heart of the family and at the foundation of broader society. Second, each tradition recognizes that marriage has inherent goods that lie beyond the preferences of the couple. One fundamental good of marriage emphasized by Judaism, Christianity, Hinduism, and Confucianism is that the husband and wife complete each other. Indeed, they are transformed through marriage into a new person, a new one, fresh reality. Another fundamental good of marriage is the procreation and nature of children. Lord, this is not an archaic concept. Special Marriage Act uses the word procreation. Children are sacred gifts to a married couple who carry forth not only the family name, lineage, and property, but also the community's religion, culture, and language. All these religions thus see a close relation between marriage and children, just as they saw a close relation, although not an identity, between marriage and sexual expression. And all these religions teach that stable marriages and families are essential to the well-being of children. This is what my Lord Kara says in the adoption. 2 years of stable relationship as husband and wife. Third, each tradition regards marriage as a special form of sacrament, promise, oath, or contract over any generic relationship, economic or social. It has a special, unique status, my Lord. For Hindus, it is a sacrament. For Muslims, it's a sacred contract, but nonetheless a sacred contract. And across the faith, what is recognized as a marriage is between heterosexual couple. Fourth, each tradition eventually came to insist that marriage dependent in its essence on the mutual consent of the man and the woman. Even if the man and women are represented by parents or guardians during the contract negotiations, their own consent is essential to the validity of their marriage. Jewish, Hindu, Confucian, and Muslim writers came to this insight early in the development of marriage. The Christian tradition reached this insight canonically only in the 12th century, and Buddhism more recently still. Fifth, marriage is a concept that is deeply embedded as a union between two opposite sexes ordained by the religious text and practices, specifically for the furtherance of society and the orderly influence between persons inhabiting the society and following specific religions. Now, your lordships have a variety of shades to be dealt with, variety of problems which are to be encountered, variety of religions and their personal laws, my lord, intermingling, and your lordships have an option on, in my respectful submission, possibly the only constitutionally permissible option, to require the parliament or to wait for the parliament to do that. My lord, please now come to page 16. My lord, I am citing some judgments. I will not read all, but these are, my lord, some very illuminating judgments, my lord. At page 17. My lord, right.
17.
17. It starts at 16. The title is Democratic Right of People to Regulate Themselves.
You said
we as a society has a right to regulate ourselves.
17.
Okay. Lord, PDF 25. 21, my lord. PDF is 21, my lord. We as a society, my lord, govern who will be the components of that society, my lord, and that governance comes in, my lord, the elected representatives whom we decide, my lord, to elect. Now, please come, my lord, this Reynold Rajmani judgment. I'll read only the highlighted part, my lord, so that I don't invest your lordships more time. It cannot be denied that society is generally interested in maintaining the marriage bond and preserving the matrimonial state with a view to protecting societal stability, the family home, and the proper growth and happiness of children of the marriage. I'll skip the rest, underline portion. But although the grounds for divorce have been liberalized, they nevertheless continue to form an exception to the general principle favoring the continuation of the marital tie. In our opinion, when a legislative provision specifies the grounds on which divorce may be granted, they constitute the only conditions on which the court has jurisdiction to grant divorce. If grounds need to be added to those already specifically set forth in the legislation, that is the business of the legislature and not of the courts. Lord, please, Lord, see these, my lord, in light of what I'm going to show. The structure of the Special Marriage Act would be, if it is redrafted the way petitioners have prayed for. Even their prayers are, my lord, absolutely vague. I'll be able to demonstrate that. But first, my lord, law on the point. 5. When therefore Section 10 of the Indian Divorce Act specifically sets forth the grounds on which a marriage may be dissolved, additional grounds cannot be included by the judicial construction of some other section unless that section plainly intends so at the foot. However, whether a provision for divorce by mutual consent should be included in the Indian Divorce Act is a matter of legislative policy. The courts cannot extend or enlarge legislative policy by adding a provision to the statute which was never enacted there. Therefore, I started by saying that marriage is a socio-legal institution. Its recognition is a matter of legislative policy. Then, my lord, Keshavanand Bharti, my lord, kindly allow me to read, my lord. This would guide, my lord, us throughout, my lord, the hearing of this case. How we construe the constitution in the context of the marriage being given the recognition, my lord. Underline portion. It cannot be denied that provisions of the constitution of other countries are designed for the political, social, and economic outlook of the people of those countries for whom they have been framed. The seed of the constitution is sown in a particular soil, and it is the nature and the quality of the soil and the climatic conditions prevalent there which will ensure its growth and determine the benefits which it confers on its people. We cannot plant the same seed in a different climate and in a different soil and expect the same growth and the same benefit therefrom. Law varies according to the requirements of time and place. Justice thus becomes a relative concept varying from society to society according to the social milieu and economic conditions prevailing therein. The problems which confront those courts in the background of the state of the society, the social and economic setup, the requirements of people with a totally different ethics, philosophy, temperament, and outlook differentiate them from the problems and outlook which confront the courts in this country. It is not a case of shutting out light where they could profitably enlighten and benefit us. The concern is rather to safeguard against the possibility of being blinded by it. Lord, this takes us to, my lord, the theory that ultimately societal acceptance is one of the considerations for recognition of any union. And that can be tested only in the legislature. And, my lord, there is a beautiful passage I'll read, my lord, from the American Supreme Court, which says that any recognition by the court does more harm to LGBTQ plus community than help them. Because then you are forcing something which should have come from within. That's the logic, my lord, of the Honorable Supreme Court. Now, my lord, A.K. Roy, my lord, 5-judge bench. I'll read, my lord, the highlighted part. But we cannot transplant in the Indian context and conditions principles which took birth in other soils without a careful examination of their relevance to the interpretation of our constitution. No two constitutions are alike, for it is not mere words that make a constitution. It is the history of the people which lends color and meaning to its constitution. Lord, we cannot forget the historical background and the anthropological background, my lord, which eventually resulted into creation of an institution called marriage across faiths, across religion. Now, my lord, your lordships have seen, but my lord, Justice Cardozo, my lord, a little hard-hitting, my lord, word, but my lord, it really, my lord, I would wish, my lord, to place it. When they say that all we want is a recognition, all we want is the confirmation of our right. The judge, even when he is free, is still not wholly free. He is not to innovate at pleasure. He is not a knight errant roaming at will in pursuit of his own ideal of beauty. I'm sorry.
It's the nature of the judicial process.
That's correct. That's correct, my lord. But, my lord, only few words I wanted to highlight, my lords. Not the first part, which is slightly, my lord, a little more harsher, my lord. But thereafter, he is to draw his inspiration from the consecrated principles, and this is important, He is not to yield to spasmodic sentiment, to vague and unregulated benevolence. That's what, my lord, I am driving at. The class with which, my lord, your lordships are dealing is an unidentifiable class. They have their class-specific problems. It would be completely, my lord, a vague declaration, if at all it is to be made, without, my lord, conceiving the problems they would be creating, my lord. The mere declaration would continue. He is to exercise a discretion informed by tradition, methodized by analogy, disciplined by system, and subordinate to the primordial necessity of order in the social life.
Primordial.
Sorry, primordial.
I think our own Justice Patanjali Shastri has put it all in that one short paragraph in V.G. Rao. Everything that is on reasonableness and
Yes,
what is the
yes.
role of the court.
Yes. Lord, kindly come to, my lord, para 74, para 73, 74, and 75. This would be relevant, my lord, for my purpose, because I'm going to, my lord, rely upon Obergefell, Windsor, and, my lord, their dissent. A beautiful dissent, because for us, both, my lord, majority, minority, both are having persuasive value. It was a thin majority of 5 versus 4. But numerically, yes, majority, my lord. Dissent is a dissent, but, my lord, which would really assist your lordships. Now, your lordships may kindly see the landmark dissent of Justice Oliver Holmes in Lochner versus New York, which criticized the majority of the court for becoming a super legislature by inventing a liberty of contract theory, thereby enforcing its particular laissez-faire economic philosophy, is still remembered as a remarkable piece of judicial foresight. My lord, then I have cited, my lord, this judgment with a reason. My lord, please allow me to cite Daybright Lighting. I'll just read, my lord, the highlighted part.
Yes.
Our recent decisions make plain that we do not sit as a super legislature to weigh the wisdom of legislation, nor to decide whether the policy which it expresses offends the public welfare. Lord, 75, and before I, my lord, read that, my lord, I would like to, my lord, just paraphrase it. Specifically, the dissent of Justice Holmes came to be fully accepted in Ferguson versus Krupa and continues to be the law of America till date. Interestingly, the dissent in both same-sex marriage cases in the American Supreme Court in Obergefell versus Hodge and United States versus Windsor blame the majority for committing the same mistake it did in Lochner suit. I'll read, my lord, and thereafter what happened after, my lord, this Obergefell judgment in Dobbs. This is doubted. Now, your lordships may, my lord, kindly directly come to, my lord. My lord, rest of the judgments are same, that your lordships would not, Lord, as a prudence and as a policy, substitute the wisdom of the legislature. But, my lord, kindly come to page 23, that is, my lord, 27 PDF. Only the highlighted part. Your lordship gets, my lord Justice Narsingh. Lord, page 23, PDF 27, my lord Justice Bhatt and Justice Kaul, my lord.
Yes.
Read the highlighted part. The power of the court to legislate is strictly limited. Judges ought to remember that their office is just decree and not just dere to interpret law and not to make law or give law. Chief Justice Chandrachud, my lord, this can be, my lord, said now, my lord, that's my request. Chief Justice Chandrachud can say this, my lord, in the present judgment, my lord, on the lighter side, my lord. Chief Justice Chandrachud, speaking for a constitution bench in Gurbakh Singh, CBI versus State of Punjab, has clearly pointed out the limited powers of the court to make laws in construing the provisions of the statutes. The learned Chief Justice has observed the true question is whether by a process of construction, the amplitude of judicial discretion which is given to the High Court and the Court of Session to impose such conditions as they may think fit while granting anticipatory bail should be cut down by reading into the statute conditions which are not to be found therein. Our answer clearly and emphatically is in the negative. Nothing more can be read into the statute. Then, my lord, again the learned Chief Justice warned, judges have to decide cases as they come before them, mindful of the need to keep passions and prejudices out of their decisions. And it will be strange if, by employing judicial artifices and techniques, we cut down the discretion so wisely conferred upon the courts by devising a formula which will confine the power to grant anticipatory bail within a straitjacket. Therefore, even if we were to frame a code for granting of anticipatory bail, which really is the business of the legislature, it can at best furnish broad guidelines and cannot compel blind adherence. The court, by its very nature, are most ill-suited to undertake the task of legislating. There is no machinery for the court to ascertain the conditions of the people and their requirements and to make laws that would be most appropriate. Further, two judges may think that a particular law would be desirable to meet the requirements, whereas another two judges may most profoundly differ from the conclusions arrived at by two judges. Conscious of these handicaps, the law requires that even an amendment of the Supreme Court rules, which govern the procedure to be adopted by it for regulating its work, can only be effected by the whole court sitting and deciding. Lord, the court puts a word of caution that though, my lord, one of the finest, my lord, intellectual brains of the country would be deciding this, but that would not reflect the will of the people. Then, your lordships, my lord, kindly come to page, my lord, I'll just read, my lord, at page 24, that is 29 foot. My lord, it's a constitution bench judgment and only the highlighted part at page 29, my lord. 25, my lord, PDF 29. The court also needs to be mindful that a legislation does not become unconstitutional merely because there is another view or because another method may be considered to be as good or even more effective, like any issue of social or economic policy. It is well settled that the courts do not substitute their views on what the policy is. But my respectful submission is policy throughout all legislations, including Special Marriage Act and Hindu Marriage Act, is recognition of marriage as a socio-legal institution between heterosexual couples. That policy can be reviewed, reconsidered, and redecided by the Parliament, having, my lord, after having wider consultations and, my lord, after gathering all the facts, gathering all possible scenarios which need, my lord, to be regulated. Now, your lordships, my lord, come to page 26, my lord. 20, that is 30, PDF 30. First unnumbered paragraph, my lords. Does my Lord Justice Bhatt and Justice Kaul as well? Yes. May I read, my lord, with my lord's permission? Yes. Your lordship gets one. My lord, the Chief Justice gets one.
Page 30, right?
Yes, PDF 30, my lord.
Yeah.
First unnumbered paragraph.
Yes.
This understanding has also come to be judicially accepted even in the United States, which had earlier permitted same-sex marriage by judicial decision. The United States Supreme Court in Dobbs versus Jackson Women's Health Organization has held that fundamental rights must be objectively, deeply rooted in the nation's history and tradition. Justice Clarence Thomas, in his concurrence in Dobbs, noted specifically that this meant that the court should reconsider Obergefell versus Hodge, which 5-4 permitted same-sex marriage by a judicial verdict, in which the Supreme Court by a judicial order granted recognition to same-sex marriage. Further, the majority led by Justice Alito in Dobbs' case was emphatic in what it referred to as usurpation of power by the court and held that the issue be returned to the elected representatives. After doubting Obergefell, which permitted same-sex marriage. And in Dobbs, they say, we send it back to the elected representative, namely the Senate. Lord, please read, my Lord, Justice Alito. Roe, my Lord, that is Roe versus Wade, my Lord, your Lordships are aware. Roe was on collision course with the Constitution from the day it was decided. Casey perpetuated its errors, and those errors do not concern some arcane corner of law of little importance to the American people. Rather, wielding nothing but raw judicial power, the court usurped the power to address a question of profound moral and social importance that the Constitution unequivocally leaves for the people. Casey described itself as calling both sides of the national controversy to resolve their debate, but in doing so, Casey necessarily declared a winning side. Then again, my Lord, highlighted the underlined part. Put aside the second and third factors, which were based on the court's flawed account of history, and what remains are precisely the sort of considerations that legislative bodies often take into account when they draw lines that accommodate competing interests. The scheme Raw produced looked like legislation, and the court provided the sort of explanation that might be expected from a legislative body. Lord, reasons which the petitioners urge are the reasons which can be given, accepted, rejected by the Parliament. Our decision returns the issue of abortion to those legislative bodies, and it allows women on both sides of the abortion issue to seek to affect the legislative process by influencing public opinion, lobbying legislators, voting, and running for office. Neither decision has ended debate over the issue of a constitutional right to obtain an abortion. Indeed, this case, 26 states expressly ask us to overrule Roe and Casey and to return the issue of abortion to the people and their elected representatives. The states were before the court. So out of 51, 26 said that you overrule this. Return it to us. It's our domain. This court's inability to end debate on the issue should not have been surprising. This court cannot bring about the permanent resolution of a rancorous national controversy simply by dictating a settlement and telling the people to move on. Whatever influence the court may have on public attitudes must stem from the strength of our opinions, not an attempt to exercise raw judicial power. We do not pretend to know how our political system or society will respond to today's decision overruling Roe and Casey. And even if we could foresee what will happen, we would have no authority to let the knowledge influence our decision. We can only do our job, which is to interpret the law, apply long-standing principles of stare decisis, and decide this case accordingly. We therefore hold that Constitution does not confer a right of abortion. Roe and Casey must be overruled, and the authority to regulate abortion must be returned to the people and their elected representatives. We end this opinion where we began. Abortion presents a profound moral question. The Constitution does not prohibit the citizens of each state from regulating or prohibiting abortion. Raw and Casey arrogated that authority. We now overrule those decisions and return that authority to the people and their elected representatives. Now, my Lord,
Mr. Solicitor,
yes, ma'am.
These judgments which you have cited on the limits of judicial power, that principle of law is well settled. I mean, there's no question about it, that judges don't legislate. The power to frame law, to look at the myriad different social complexities, is entrusted to the legislature, whether at the center or in the states.
Yes, ma'am.
That principle is a well settled principle. But if you are relying on Dobbs to support that principle, then we have gone far beyond Dobbs in India.
I know, my Lord. I know. I'm going to cite your Lordship. Yes.
Dobbs represents a view of the American Supreme Court that a woman has no bodily control over her own bodily integrity.
I'm not.
This theory has been debunked long back in our country.
Correct, my Lord.
So therefore, I mean, you're citing the wrong
judgment.
You're citing the wrong judgments in support of the principle.
Lord, the principle is that the issues concerning moral or social implications be returned to Parliament. That's the limited point.
Fair enough. But don't cite Dobbs, because we have gone far beyond Dobbs here. And fortunately so.
Lord, Dobbs have cited.
I think we can at least credit ourselves that, we are far ahead of our times than many of the Western countries in their jurisprudence.
Lord, I am never a fan of, my Lord, citing foreign judgments. My Lord,
and certainly not Dobbs.
No, my Lord, I would say none. But, my Lord, not Dobbs. I understand. My Lord, Dobbs, we may have an issue, my Lord, even I have a personal issue with the subject matter it dealt with. We are not concerned, my Lord, with the subject matter Dobbs dealt with. Abortion is a right of autonomy of a woman. I'm not on that question at all. I'm on the principle which it laid down.
For instance, our law granted only to a married woman the right to obtain an abortion between 20 and 24 weeks. We dealt with that restriction. When an unmarried woman came before us and said, well, I must assert an equal right to an abortion. And we upheld that right, saying,
my Lord, I'm at the cost of repetition.
We have gone far beyond. I mean, much of the recent jurisprudence, on Dobbs and the overruling of Roe versus
I am at the cost of repetition.
Said on this jurisprudence, actually.
Lord, at the cost of repetition, I say, Dobbs is not relied upon for what it decides on the facts of that case. That we have proceeded much further, and we have always been much ahead of America or any Western countries in every which way. Unnecessarily, we follow the
principle that on complex social and moral issues.
That's the only limited ratio which I am relying upon.
Definitely, and legislature, that point is well taken, but not.
Yes, that's the limited point. My Lord, I am not supporting, my Lord, the judgment on abortion rights, my Lord. Obviously, your Lordship knows, my Lord, everyone has a problem with that. But question is, when it concerns a debate, when it concerns social implications, return it to the people's representative. That is one reason. Second reason, my Lord, this Obergefell is doubted here, which petitioners have relied upon. Lord, that is one reason. My Lord, forget the abortion part of it. I am not supporting that judgment. But I am nobody to support or oppose that judgment. I am citing it only for this limited purpose of showing that this is an issue which must be first reflected, debated, discussed, and, my Lord, decided by the Parliament. That's the limited purpose. But please see, my Lord, Justice Clarence Thomas, my Lord, my Lord, only highlighted part, only underlined portion. Forget, my Lord, the this abortion part. I'm not on that, my Lord. I also, my Lord, do not agree. Your Lordship's judgment in, my Lord, termination of pregnancy takes care of it. I'm not on abortion at all. My Lord, that's fact specific. But while dealing with some facts, when your Lordship lays down the ratio, I cite it. This is the ratio.
Fair enough.
Lord, please see, my Lord, only highlighted part. My Lord, Obergefell versus Hodge. My Lord, your Lordship gets, my Lord?
Yes.
My Lord, concurring view of Justice Clarence Thomas. For that reason, in future cases, we should reconsider all of this court's substantive due process precedents, including, then, my Lord, they inter alia. My Lord, I'm not reading all, but, my Lord, even this Obergefell.
But going by this logic, we would be reconsidering the entire line of our precedent from Maneka to Shaira, which is not your submission also.
It's not my submission. It's not my submission. But my submission is, my Lord, the last part of Justice Alito.
Yes.
Social implication, return it to the Parliament. That's it. My lord, now, my lord, I have given the table. My lord, I'll read, my lord, those judgments a little later, but please come to page 29. I'm sorry. Go ahead. Yeah. I'm sorry, if I... Lord, page 29. Lord, I have compiled for your lordship's assistance, Lord, two things. The countries where same-sex marriage is permitted.
Yes.
And I have bifurcated them that except with the 2 or 3 exceptions that came from legislature and not by the judicial pronouncements.
Right.
Number 1. Number 2. Lord, as I have pointed out, this is not something crucial. Lord, when your lordships recognize something or the legislature recognizes something, it will have impact on other laws, which I will demonstrate. Wherever the legislature has stepped in whichever country's jurisprudence, they have correspondingly amended other statutes, which only Parliament can do. None of the other statutes are in question before your lordships. So the suggestion of the petitioner that keep the threads hanging, that is not permissible. But that is taken care of by various statutory amendments by various.
Let's have a quick glance at these.
Well, kindly have Endora, my lord, by legislature. Then, my lord, I'll just, it's a, my lord, translation. It was originally, my lord, we got it translated. It's a Google translation. I must, my lord, at the outset put a caveat, my lord. There may be, generally, it's not, my lord, much of discrepancy, but maybe some lacking in accuracy. Marriage contracted in civil form has the same requirements and effects, whether both contracting parties are people of the same or different sex. So this is what, my lord, the new statutory regime brought by the legislature says, but what is important is legislature made following consequential changes. The Amendment Act of February 2023 amending the following provisions: Article 77 of the Family Code on forms of marriage, 78 of the Family Code on effects of civil and canon marriage, Article 91 on civil consequences of entering into a canon marriage, and Article 244 on the competence of Andorran authorities to celebrate civil marriage. Maybe some local requirements there. But the point is that whenever legislature does it, it applies its minds and makes corresponding changes. Then Argentina, by legislature. Translation: marriage will have the same requirements and effects regardless of whether the I'm sorry, my lord.
Yeah.
My lord, possibly, my lord, Justice call is on mute, my lord, if your lordships are asking me something.
No. I am right there where you're reading it.
Oh, I'm so sorry. I thought my lords are putting some question.
I was putting a question. I was trying to put a question.
Yeah, I'm so sorry, my lord.
Rather a suggestion. Instead of reading the whole lot, I think this is a chart which segregates, puts a classification.
Correct.
Out of the 34, there are 34 countries. Of that, 29 countries are straight away legislated.
All of them.
And even the legislatures are done in a graded manner.
Correct.
And in 9 other cases, these legislations have been preceded by some court directions or decisions.
Reverse, my lord. It's converse. If your lordships comes at page 42, that is 46, my lord, PDF 46, I have given. My lords may, my lord, come to page PDF 46. Your ladyship may see, my lord, I have given.
Legislation is the legislative process 24. Countries where the recognition was through a mixed process initiated by the
initiated largely by legislature or executive. But then, my lord,
South Africa is one.
Court stepped in.
South Africa is the exception in that sense.
Yeah, yes.
But then I think you have also to take into account Taiwan and Austria.
Yeah, I know, my lord, but kindly turn the page over. I'm sorry, my lord. Taiwan, please see, my lord, page 41. My lord, that is 45 PDF.
Yes.
I'm going to, my lord, read, my lord, Taiwan Supreme Court also, my lord, where the dissent also will be illuminating, my lord, to your lordship. My lord, mixed process. Taiwan, your lordships have, my lord?
Yes.
My lord, Justice Butt and Justice Call has, my lord?
Number
Yes.
31.
Number 31, yes, ma'am, number 31. Mixed process. From 2015 to 2017, several municipalities, local governments of Taiwan, like so-and-so, 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 allowed registration for same-sex marriages and allowed civil union of sorts. In 2017, the Ministry of Interior formally asked all local governments to open registration for same-sex couples. It was after the said legislative or executive process that in Judicial Yuan Interpretation number 748, the Constitutional Court further expanded rights to allow formation of permanent unions to include same-sex couples. It started initially by legislature, then executive stepped in, and then the judgment, my lord, of...
Now you have the law, I think, in 2019.
Yes, my lord.
And even in Austria, now let's see, because Austria is one case which was given, which is shown to us.
My lord, page 34, your lordship would get. My lord, the Chief Justice, 34 PDF. 34 is Austria.
Yes. Now, what is the position? Even there, it was followed by legislation.
Yes, my lord, legislature provided for registered partnership for same-sex couples in 2010. The relevant provision in section 3, my lord, translation, a registered partnership can only be founded by two people, registered partners. In this way, they form a long-term partnership with mutual rights and obligations. Role of court. In January 2013, the Constitutional Court ruled that the registered partnership law was partially unconstitutional, broadening the rights of registered partners. On 4th December 17, the Constitutional Court struck down the ban as unconstitutional, ruling that preventing same-sex couple from marrying violates the principle of equality and non-discrimination. Lord, there was a prohibition which came to be challenged. Lord, therefore, Lord, I started by saying...
As in the case of Windsor. As in Windsor. Windsor also the prohibition was challenged.
Because there is, your lordships are not, my lord, confronted with a situation where there is a law prohibiting same-sex couple, my lord, marriage.
The UK was a situation where they first recognized by a law civil partnerships in 2006.
I think that
after 7 years later, they enacted the Marriage Act.
Yes.
UK is very interesting. You might read that.
You just see the UK, actually, your page, item 32.
Yes, ma'am.
At PDF 45.
Yes, ma'am. I'll just...
United Kingdom. Gaidan was 1999 or 2000.
Lord, Gaidan, my lord, was, my lord, cited out of context, my lord, and I have, my lord, given a detailed note on Gaidan in this.
Mr. Solicitor, just keep ourselves to this, because Gaidan was in some other context, one realizes. That was in the context of a tenancy where...
One, my lord, Rent Act was in question. That apart, even there is another, my lord, fundamental, foundational distinction, which, my lord, I'll come to, my lord. But please see item 32 by legislature. And Civil Partnership Act 2004 came into effect in December 2005.
Actually, in the context of a tenancy, the real principle is of settled residence. So the law gave protection to the surviving spouse of an erstwhile tenant. Why is that protection given? We also have it in our Gyan Devi Anand, that whole line of cases from the Constitution bench. The idea is that when a tenant dies, anybody who's in settled residence as a member of the family should also be entitled to the protection of tenancy, which is otherwise a heritable asset. That's the principle. Gaidan also said the same thing, that, well, if you have a same-sex couple, even though the statute doesn't recognize a same-sex surviving spouse, the principle they adopted was, the principle is really that of a settled residence. And the idea is to protect, as a matter of social welfare, one of the occupants of that particular tenancy, then that should not be deprived to a same-sex surviving spouse.
Your lordships are right. That was the fact. But, my lord, forgetting the fact, the principle which was relied upon was fundamentally flawed, my lord, and that's my separate argument. Why, my lord, Gaidan would not apply in the Indian context.
Just read now 32 at internal page 45.
32, my lord, I was at 32. United Kingdom, the Civil Partnership Act 2004 came into effect in December 2005. It created civil partnerships which gave same-sex couples who entered into them most of the rights and responsibilities of marriage. Thereafter, the Marriage Act 2013 for
Mr.
England and Wales.
Mr. Solicitor, this act, you described it in a very classical form, but actually that resulted in amendment to a lot of other enactments in 2004 itself.
Yes, my lord, your lordship would find that at PDF 549. My lord, volume 5 of our compilation, PDF page 549. 2013 Act, my lords, we have placed them on record. Place that act on record. That is marriage within bracket same-sex couples bracket over Act 2013.
So that resulted in a amendment to various other enactments.
And
That
then
is also, my
then
lord,
2013 led to a series of amendments thereafter.
correct, my lord. That is also, my lord, part of that, my lord. I'll come to that, my lord, after showing this. Because right now this chart was only for the limited purpose of showing that it initiated by the legislature, except in case of, as my lords have rightly said, my lord, Taiwan and Taiwan also not fully, but South Africa. And South Africa I have mentioned, my lord, at page 43, my lord, that is 47, PDF 47. Now, your lordships gets, my lord, at the top, my lord, the Chief Justice gets, my lord.
Yes.
Possibly the only country subject to verification, but we tried our best to verify. South Africa is the only country where the process was first initiated by judiciary and then followed by.
Which is Furi's case. Furi, which was read out by Mr. Grover.
Yes, my lord. Then, my lord, countries where civil unions are legal. That also, my lord, we have given. But I'm not going one by one.
No, just we'll just only look at the headings of the.
Yeah,
and if we
that's
come
right.
across any one of us comes
There are
across
some-
something interesting, we can pause
There are
there.
some mixed processes.
Yeah, my lord.
indicate.
For example, Bolivia is by judiciary.
Brazil,
Because, my lord,
India.
Second Constitutional Chamber of La Paz Department Court of Justice, citing advisory opinion number so-and-so, issued by the Inter-American Court of Human Rights, ruled in favor of the couple recognizing same-sex civil union. However, it may be noted that several bills had been introduced in the country's legislature seeking recognition, and the political debate was ongoing on the said issue.
Look at Latvia. Something very interesting happens in Latvia at item 9.
Yes, my lord. By judiciary first, thereafter legislature. Latvia does not recognize same-sex marriage, but same-sex couples are able to register their partnerships with the government through the courts. On 12th November 2020, the Constitutional Court of Latvia ruled that the Latvian constitution entitles same-sex couples to receive the benefits and protections afforded by Latvian law to married opposite-sex couples, and gave so-and-so until 1st June 22 to enact a law protecting same-sex couples. My lord, that may be, my lord, as per their constitution. My lord, your lordships never issue a writ to parliament.
A lot of countries, of course, we don't follow that model, Mr. Solicitor. I mean, we are now discussing at a theoretical level. Some countries have followed this doctrine where the judiciary say we give you 3 months to take steps to enact law, for instance, so 3 years or 1 year or whatever. If you don't, then this will follow. So Latvia seems to have followed that.
That, my lord, but that, my lord.
No, I began by saying that we have not, we scrupulously say no mandate.
Your lordships have always, my lord,
to parliament.
scrupulously, my lord, never issued writ.
There are countries which follow that, we declare the law, we give you so much time, put the law in order.
Depends upon the constitution. Like, my lord, in Great Britain, the parliament is completely sovereign. My lord, there is no power to declare the law unconstitutional, etc. My lord, that depends upon the constitutional culture, as I say, my lord. But our, my lord, constitutional position has been consistent, my lord.
Let's scroll down.
Then, my lord, summary is at page 49 PDF. civil union position, then countries where civil union or a partnership arrangement is given recognition, 16, countries where recognition was through purely legislative process, 13, and country where process was mixed, 3. Number 98. Therefore, it is clear that societies and countries have acted only after the said concept has gained currency or acceptability in their respective jurisdictions, and the elected representatives have acted on the basis of locally prevailing ethos, beliefs, and understanding of marriage or civil unions. It is submitted that therefore there was a clear and direct democratic mandate behind the recognition of same-sex marriages in which ever jurisdiction such relationship were recognized.
Mr. Solicitor, if you don't mind, can we now just skip a little bit and go to page 54? Let's now go to the heart of the matter, which is the legislative intention behind this, because you've given us a flavor now.
Yes,
Substantially gone through your, isn't
Could
it?
your lordships, my lord, consider coming to page 50 instead?
Those judgments which say about legislative policy and other things.
Yes,
those you've given them to us, and it's very well basic doctrine. I don't think we need to read it together. Prim
lordships,
grana
indeed. My lord, the proposition is
and everything. Yes.
Some of them are constitution bench judgments. That's all I wanted to highlight. And my lord, the purpose, as I pointed out yesterday, was that I'll quote the paras rather than burdening the volumes, my lord, so that your lordships can immediately.
Brother Call and Brother Bhatt are not here. I don't online. They're online. I think those judgments at page 50 to 54, we need not spend time going through them, right? It's basic doctrine, so they're well known. So we can just maybe look at them and go to the real
legislative intention behind Special Marriage Act. And
I think yes, exactly. We'll go straight to page 54. I think.
Your lordship, sorry, page PDF page 54.
Lord, the purpose is say that those judgments are not relevant, but there's just they're so basic that I don't think we need to spend time reading through them. That's why.
There are settled positions your lordships are fully aware of. This is just, my lord,
let's see now how you've formulated at page 54 PDF.
Yeah, my lord, 54, my lord, I'll just put, my lord, two propositions. Why, my lord, I am going through the debates. It might at some time, my lord, appear to be a little irrelevant, but please go through it. My lord, this is the debate when Special Marriage Act 1954 came to be enacted for two purposes. A, the intention was heterosexual, intra-faith, but heterosexual.
Just 1 second.
I'm sorry, interfaith, interfaith, intercaste, but heterosexual.
Religious and irreligious, or no religious?
Yeah, yes.
It's only distinction between
actually it was religion neutral.
Correct.
The SMA was intended to be religion neutral.
Yes. I would, my lord, nothing turns on that, but just academically, my lord.
Idea was because to create a platform where couples were not going to marry within the fold of their personal law.
The faith.
In that sense, religion neutral.
I'll just, my lord, just academically, nothing, my lord, may perhaps turn on this. Even if I accept that it's a secular law or a non-religious law, it has taken some concepts of uncodified Hindu law. For example,
of course it does. Prohibited relationship.
Degrees of prohibited relationship. That is Sagotra and Sapinda relationship.
Absolutely.
But in the format of, my lord, a religious or a non-religious statute. Some concepts, my lord, are there.
The whole object was to permit two couples, two individuals who profess different faiths to have a
two different individuals of opposite sex.
That's what we are now considering. But the idea was basically it was to allow two people who did not profess the same religion to have,
or maybe the same religion but different castes.
Correct. You're right.
Because section 21A.
That's why Arundhati referred to the Caste Disability Act and other things.
Dr. Ambedkar piloted this bill, and this is before.
The reason was, my lord, your lordships have been shown, my lord, by Ms. Kaju. Lord, it was earlier 1872 law, where if I marry under that Special Marriage Act, I have to denounce my religion. So therefore, my lord, that was brought back by 21A.
Mr. Solicitor, you'll not be completing today. So tomorrow when you resume, maybe if one of your juniors can do a little exercise taking from the table which Ms. Kaju has prepared.
Yes, yes.
And give us a 2-page note or 3-page note on the antecedents of the SMA.
Yes, yes.
Just take, you will get the material from that note and just sort of develop it into a 2 or 3-page note for us tomorrow morning.
To some extent, my lord, I've set out some of the materials of the debates and so on in the additional compilation which I had filed.
Do we have the statement of objects and reasons?
Yes, we do. So which refers again to...
No, debates also mentions that. My lord, there is
Well,
a
let's
flavor
see that page
in the debate.
54.
Well, the second point, my lord, your lordship may bear in mind. My lord, it was argued that in 1954 there was no concept of gays, etc. And therefore, obviously, there was no mention. Your lordship, my lord, that was Mr. Rodgi's submission. My lord, my respectful submission, my lord, and I'll take your lordship to that, are twofold. A, even if that is so, that is no ground for the court to rewrite and include something not intended. B, they were aware of it. There is a discussion on that. And therefore, I'm going to respectfully submit that there is a conscious omission. That's one more reason why it cannot be read into. Lord, may I read, my lord? This, my lord, I may read a little, my lord.
Yes, that's right.
105. At the outset, it may be noted that if the principle canvassed by the
just one
petition...
second. 1 minute. Is that page,
I'm sorry.
Page 50.
It is 54
Page 54,
PDF.
Same volume.
54. Okay.
Yes.
Lord, its title is Redrafting Exercise of Special Marriage Act, your lordship gets. My lord,
Yes.
Justice Narasimha gets. Yes. At the outset, it may be noted that if the principle canvassed by the petitioners, that word man or woman or other phrases representing the two opposite sexes are capable to interpretation in a gender-neutral manner, it would open up a whole host of statutes and provisions to constitutional susceptibility. My lord, your lordship can skip that. 106. As far as the present case is concerned, the debates in Parliament during the framing of the Special Marriage Act and the Hindu Marriage Act 1956 are illustrative in this regard. The said debates clearly identify that the entire architecture of the statutes was premised on opposite sex marriages, and the provisions surrounding the legal recognition of marriage, the succession amongst children, and other aspects are all completely premised on the legislative presumption of opposite sex marriages. The Parliament was aware of gays and lesbians even in 1954. However, it is clear that the Parliament took a conscious call of not mentioning them. It is interesting to note that the Select Committee on the Special Marriage Bill 1952 approved Section 4 of the bill in a form which did not use the word male or female and rather use the word parties. The clause is quoted as under, my lord, as per Select Committee. The parties have completed the age of 18 years. Each party, if he or she has not completed the age of 21 years, has obtained the consent of his or her guardian to the marriage. This is substantially what they want, my lord, to reinterpret. It was after a heated debate going on for days and days that Pandit Thakur Das Bhargav brought an amendment that provided for separate ages for boys and girls in the form of 18 years and 21 years. It should be reverse. Boys and girls respectively 21 years and 18 years. It is submitted that apart from the above, the debates clearly show the limited purpose behind the enactment and the clear, unequivocal understanding of marriage as an institution between opposite sexes. The speech of learned Minister of Law and Justice at the time, Sri Charan Chandra Biswas, is illustrative in this regard. The relevant portion of the debates are as under. Then Sri Biswas. Let me now refer specifically to some of the salient features of the bill. The first is, as I have already pointed out, marriage under this law will not require the parties to forswear their religion or to declare that they do not belong to any religion. Any two persons residing in India will be eligible to marry under the provisions of this law. It is permissive, no doubt, but it is compulsory only to this extent that if they marry under this law, the conditions herein laid down must apply. They must make up their minds as to whether they wish to be subjected to these conditions. If they do not choose to be subjected to these conditions, it is open to them to discard this and to marry according to the law which now governs them. That was, my lord, personal uncodified law, which does not prohibit LGBTQ plus marriages. Yes, except, my lord, in case of LGBT. Yeah, yes, my lord, Hindu Marriage Act prohibits. Yeah, my learned friend is right. My lord. The Act of 1872 applies to two categories of persons. Firstly, to persons who do not profess any of the major religions of the country, and secondly, to persons who profess the Hindu, Buddhist, Sikh, or Jain religions. The result is that this Act does not permit any inter-religious marriages unless the parties are prepared to forswear their religions. If they are Hindus, then both of them must be Hindus. If they are Buddhist, both of them must be Buddhist. If they are Sikhs, both of them must be Sikhs. And if they are Jains, both of them must be Jains, in order that they may marry under the Act of 1872 as it stands now. For the first time now, we are going to do away with all distinctions based on religion. The bill, if passed, will permit of inter-religious marriages. Religious differences are put out of the way altogether. Government feel that the time has now come when religious differences should not stand in the way of a couple getting together. If they feel that their lives are cast together and the fact of their marriage should not in any way affect their religious belief, that is the main change. This is the legislative intent, my lord. Now, Mr. Sri Biswas, my lord, the underlined portion. Under the provisions of the original, I may read, I'll read the underlined portion. Under the provisions of the original act, none of the parties to the marriage could belong to any of the recognized forms of religion mentioned therein. Now, two persons, if they belong to the same religion, will be allowed to marry. But this privilege is confined only to Hindus, Buddhists, Sikhs, and Jains. That is because the main rights which were secured by this act were monogamy and divorce. The religions which were excluded already provided for monogamy and divorce. The Christian Marriage Act is monogamous and divorce is permitted. Muslims also have the right of divorce, though it is not monogamous. Kindly, my lord, turn to the next page. Lord, nothing may turn, my lord, on other debate. Srimati Reena Chakravarti, Mr. Deputy Speaker, sir, I do not propose to answer various things that have been said just now because I feel it is very difficult to answer people whose mind still remains in medieval times. It is even more difficult to convince anybody who thinks that he himself has the monopoly of all morality and everybody else who demands progress seems to be having some problem with someone, as we can read between the lines. Himself was the monopoly of all morality and everybody else who demands progress immediately should be dubbed as irreligious. We support this bill because the principles underlying this bill is progress. The entire idea is to have contractual form of marriage without the necessity of repudiating religion, which was necessary in the Bill of 1872. This is the spirit, this is the heart and soul of the Special Marriage Act. My lord, next, my lord, speech by Sri Biswas, the Honorable Law Minister, is just to show that it was not a Brahmo Samaj oriented or Brahmo Samaj inspired piece of enactment. The Honorable Minister says that Brahmo Samaj, of course, is one of the major contributing factors, but not the sole contributing factor. Now, kindly come to, my lord, 57. PDF 57, my lord. My lord, at the third unnumbered paragraph, Sri Biswas. I was just going to read from the Act of 1872. It's, my lord, it can be avoided. My lordships may come to at the foot on homosexuality. Your lordship gets, my lord?
Yes.
At the foot, my lord, there is a title. This is debate dated 6th of September 1954. See, Raghava Hari, Penukonda. I do not wish to take up much time from the arguments that have been advanced for straying away from a thing that has been recommended by the other house. I am not satisfied that there has been a fair or a clear approach to the matter, but only there is an attempt to confuse the issue. One thing that I find is that this act was meant to afford an opportunity for advanced people. People with reformed ideas and people who are economically independent and have their own judgment, mature judgment about their course of action for the future. It is only for such people that this Special Marriage Act was intended. In the course of their arguments, members have been urging that the marriage age in the country should not be high. That is too old an age, and that therefore more people cannot come under this act. 21 and 18 was considered to be too old, my lord, in those days. It was also stated that this was only a permissive legislation to people who want to take advantage of it if they are in position to understand what they are about. You will see that the whole thing, you will see that the whole thing is made topsy-turvy. The idea was that the people who have attained a certain age, when they can make up their minds, nobody should interfere with their judgment. Now you want to reduce the age and put in a guardian. Why this spoke in the wheel? You know that this is permissive legislation, that marriage can be permitted between a person of one sex with any other person who is of other sex. This is what they understood, my lord, throughout. That is the heart and soul running, my lord, through the debate, irrespective of caste, community, religion, anything. Then you want to introduce the element of a guardian's consent. Do you expect that the guardians are more advanced than the present generation, which want to marry without the guardian's consent? I'm afraid this guardian's consent for marriage between people, which you are introducing, is going to be the cause of all that ineffectiveness of the legislation. Then Dr. Jayasuriya, I beg to move in page 9, line 43, after sodomy, insert with her homosexuality. Lord, sodomy was a ground for divorce. He said, insert this also because this is prevailing. It would come that this is now quite prevalent. Mr. Iyengar, notwithstanding the fact that prohibited degrees have been brought down, I do not know whether the next generation may not say that a brother can marry a sister. According to Mandal's law, the idiosyncrasies of parents among animals will persist or generations. My friend Dr. Jayasuriya will support me in this. Is this law to be ignored in case of men? A man must marry only a woman. He cannot marry a man. Is this all that counts? Then, my lord, on marriage between opposite sexes, Mr. Achyutan, I agree with that viewpoint. The girl and the boy must have sufficient maturity, sufficient age growth to understand the consequences by which they will be tied when they marry under the special law. So there is no necessity, no special ground, no coherent ground for saying that it must be reduced to 18. Moreover, according to me, why marriage means early responsibilities. There might be a sexual feeling, patience which will be there and all that. We must try to restrain them. According to me, youngsters cannot think of marriage before 25 or 22. It is not simple matter. It is a serious thing, so that the age limit must be at least 21. There cannot be any reduction either in case of the boy or in case of a girl. Again, my lord, they were talking of opposite sexes. And Mr. Deputy Speaker, my lord, Mr. Chaudhary. Your lordships may, my lord, kindly come to, my lord, the bottom. My lord, kindly, no, my lord, just third para, my lord, from the top.
The floor of the house can't really.
At that time, solicitor,
yes,
were there laws permitting same-sex marriages anywhere else in the world? I think
not to our knowledge, my lord. There was no prohibition, but not to.
Even in England, there was a prohibition. Till 73, I think it was prohibited. So there perhaps was no platform, no legal foundation for a marriage or a marriage like you recognized by law when this was all debated.
Lordships are right, my lord. Possibly in India also, my lord, till 56, when it became man and woman, bride and bridegroom, there was neither permissive nor prohibitive. That Shastric law, my lord, that uncodified Hindu law would apply, my lord, that may have, my lord, repercussion. My lord, page 59, PDF 59, the third from the bottom, Srimati Amu Swaminathan. Your lordship gets that, my lord. I rise to support the amendment moved by Pandit Thakur Das Bhargav, which provides that the man has completed the age of 21 years and the woman the age of 18 years. Now, my lord, what my learned friends want us to read is a person has completed the age of 21 years and a person has completed the age of 18 years. We do not know, my lord, which person, who is man, who is woman. We do not know. Unless we destroy the structure and fabric, my lord, it would not be possible to read the way, my lord, the petitioner want. Srimati Da Pala Chaudhary. I shall be still briefer than the one who have gone before me. I fully support the amendment of Pandit Thakur Das Bhargava because it is quite right that girls of 18 and boys of 21 should be allowed to marry. Then Pandit K.C. Sharma. I am rather surprised at the arguments of my friends both supporting this bill as well as opposing it. It is simple measure. In this country, in the Hindu, Christian and Mohammedan religions, marriage is predominantly governed by personal law, and these are rules of conduct for the husband and wife in all these religions. Then cases had happened when marriages were to be performed and the people did not belong to these religions. So in 1872, a law was passed, the Special Marriage Act, under which certain people who did not belong to certain religions could perform their marriages, and the basis of the marriage was contractual. That is, as human beings, the young man taking the young woman as wife and the young woman taking the young man as husband. When they took each other as husband and wife, it did not follow that they said goodbye, as Mr. Nandlal Sharma said, to everything decent in human life. That is not the question. The words husband and wife are significant words. There are certain implications, a certain significance, a certain meaning behind them. And the young man and the young girl who took each other as husband and wife undertook to observe the law of decency and good conduct in the society. It cannot be said that because they married beyond the Hindu, Muslim, Christian, or any other religion, therefore they said goodbye to everything that was good in those religions. That is not the point. For my friends' information, I may say that even in the Rig Veda it is stated that you, the young girl, go to the youngest man, be thou mother of heroic children for the good of the society. The good of the society means the good of the race. Therefore, the emphasis is not on the performance of yajna as such. The emphasis is on looping the thread of the race alive. What is important is the progeny. Therefore, the emphasis lies with regard to the race, not with regard to the religion. The contractual form, I may again mention, is not doing away with everything ethical or decent in life. The simple difference was the sacramental forms were done away with. That a Hindu was not required to go 7 times round the sacred fire. But it does not follow that because he has not gone round the sacred fire 7 times, therefore everything that was said before the sacred fire was not in the mind of the girl or boy. They say, we observe, my lord, so and so, and last line, under the proposed bill, any Indian citizen can marry another Indian citizen, of course, of the other sex. Now, your lordships would find this debate was simultaneously going on with regard to Hindu Marriage Act also. It was, my lord, a composite, comprehensive, my lord, exercise which was being done. And having the similar provision on sodomy. My lord, please come to, my lord, the bottom. On 20th December 1952, Lord, the relevant would be, my lord, Lord, 59, my lord, kindly come to 59. That would be 63, PDF 63. Taking the Lord, page 59, but a PDF would be 63. My Lord Justice Kaul and Justice Bhatt gets, my Lord. The Honorable Chief Justice, my Lord Justice Narsim. I'll just read at the foot, my Lord Shri S. Mahanti.
This is relating to Hindu Marriage Act.
This is debate of Hindu, my Lord, it was simultaneously going on. Same people, same members, same provision in, my Lord, question, but your Lordships are right, factually, Hindu Marriage Act.
No, 60. PDF 60 it starts.
Your Lordships are reading some.
Even the dates also are similar.
Triple one.
Yeah, yes, my Lord, dates are relevant. But this is 20th December 1952.
To marriage act.
And my Lord, what we read was September 54. But it was a period during which all these, my Lord, legislations came.
No. As a historical fact, of course, it's the Hindu Succession Act and the Hindu Marriage Act would have been enacted by the first Parliament, not I mean
Yes,
the
yes,
first
my Lord.
Parliament. The elections took place in 52. So
Correct,
this is
my Lord.
provisional Parliament. So when it
Correct.
took place, then looking at the nature of the Hindu Marriage Act, which came in 56, perhaps this was debated when it was enacted becomes material. Maybe there was it's documented, no, historically. That
Can I request your Lordships, my Lord, to see page 57 foot, the date on homosexuality. That is, my Lord, 6th of September 1954. Your Lordship gets, my Lord?
Yes.
Yes, it's there.
That is homosexuality in the context of Special Marriage Act. That's the debate which is going on. Then the next date is 16 September 54, 17 September 50, it should be 54, then 16 December 54. Then, my Lord, on marriage between opposite sexes, again, my Lord, 54. But if your Lordship, my Lord, comes to...
Why is 20th December 52 is mentioned against Hindu Marriage Act?
I think
that's not
Lord,
the date.
it was debated, my Lord, for
maybe.
Yes, about 2 years.
2 years.
I think that's the reason. There was a lot of discord, no?
Must have been started from 50.
I could not hear my Lord Justice Bhatt, my Lord.
Justice Bhatt is saying something.
I think there was a lot of discord. If I am not wrong, there was discord about the Hindu Marriage Act. So
yes.
Perhaps the Special Marriage Act got enacted first. So the Hindu Marriage Act might have undergone a lot of debate. Ultimately, this is the point of difference between the president also, right? Which led to the Hindu...
Correct.
Lord, we'll check. I'll
Just
check
the
up
one
and
vote of the
respond because
president.
I don't wish to be inaccurate, my Lord, in factual this thing. But if your Lordship comes to 59, that is, my Lord, 63, PDF 63, your Lordship would find the debate dated 14th December 54. This is debate of Hindu Marriage Act, but the same provision of Lord divorce being considered.
Where do you want us to read, Solicitor? Now?
Mr. Mahanti's
Hindu Marriage Act. Where do you want us to read?
Mr. Mahanti's discussion.
Yes, Sri S. Mahanti. Yes, sir. I shall be brief. I speak in support of the amendment number 135.
Page?
I'm sorry, page 63 PDF.
Yes, good.
At the foot, my Lord. Last speaker is, my Lord, Sri S. Mahanti.
Yes.
Yes, sir. I shall be brief. I speak in support of the amendment number so-and-so, which is a very innocuous one, namely, that at page 8 for line 12 to 40, the following be substituted, namely, and by either spouse on the ground that husband or wife, as the case may be, has since the solemnization of marriage been guilty of rape, homosexuality, or bestiality. It will be apparent from the wording of this amendment, sir, that it only seeks to substitute one very obnoxious, though biblical word sodomy by word homosexuality. I can well anticipate the objection that the Honorable Minister in charge of the bill would bring forward against this amendment. He may point out that the term sodomy is one which has received wide recognition in the Indian Penal Code, and therefore we cannot substitute that word by another, namely homosexuality. However more scientific and appropriate that term may be, but I would submit that it has also to be borne in mind. I'm sorry. I would submit that it has also to be borne in mind that here we are not going to make sodomy a penal offense. Therefore, it has got no relationship whatsoever to the Indian Penal Code here. We are here discussing this question in isolation. So it has no relation whatsoever to the Indian Penal Code. Therefore, I hope my esteemed friend, the Honorable Law Minister, will have no such argument to offer while replying in me second place. There is no reason to believe that sodomy is only a masculine vice. I have not time, nor is this occasion otherwise. I could have quoted chapter and verses to show that homosexuality amongst women is also today on the increase, that it is on the rising scale. I have got whole literature on this with me. Then, my lord, they discuss. Then Mr. Mohanty says, yes, sir, I submit, instead of using the term sodomy, you should use the better and more appropriate and scientific term homosexuality. Then Sri Mohanty. But before I resume my seat, sir, I wish to urge this House not to take a Philistine attitude. I would request the Honorable Minister not to take any such prudish attitude regarding this matter. We are not moving this amendment in a sense of levity. On the contrary, if you want to contribute to the solidarity of marital life, if you want to contribute to a healthy married life, and if you consider that sodomy is one of the reasons which can render married life unhappy, then there is every reason why you should also include the feminine vice of lesbianism and substitute the word homosexuality for the word sodomy. That is my submission, sir. Then, my lord, ultimately, Dr. Karmakar, my lord, puts an end to the debate by this. As I said, for the time being, let us be content with the use of the word sodomy. If homosexuality becomes a problem, we shall face it courageously. Look, this was in the context of adding homosexuality as a ground for divorce. One was saying that homosexuality and lesbianism is on the rise. Please add it as a composite word. The minister says, let it remain sodomy. If it becomes a problem, we'll face it courageously. The purpose of, my lord, my reading the debate is that it's not as if they were not aware of other spectrum other than, my lord, conventional man and conventional woman. They discuss. Initially, they start with parties. Thereafter, they discuss that no, it cannot be parties. It can be boy and girl. Then they define separate age for boy, separate age for girl. They were aware of homosexuality, but they consciously avoided even as a ground of divorce. May I continue tomorrow?
We'll continue tomorrow. Mr. Solicitor, what is...
Lord, I have, my lord, we have prepared, my lord, for our, on our side. Lord, I'm sorry, my Lord, maybe a day, my lord, 2 sessions, my lord.
My lord,
But if it spills over, my lord, an hour or so.
All right.
But my learned senior, my lord, Mr. Sibal is there. Learned AG is, my lord, I think learned AG wants to say
Lordships
something.
will have to tell me when I wish to need to address your lordships, my lord.
Lord, my apologies to Justice Call and Justice, but my lord, I'm handing over the tentative timings suggested by all councils, but it's not, it's in physical form. I'll, my lord, ensure that your lordship gets it.
Solicitor, it will reach, don't worry.
Yeah, but I ensure, my lord, that it will reach. My lord, this is the period suggested by everyone. It is, of
The
course,
time we'll see how we'll best allocate. The first few council, of course, will have give you a very substantial field for argument. The others, as in the case of the petitioners, will have to curtail their arguments.
My lords, yesterday, when I concluded my submissions, Honorable Justice Bhatt had asked for some documents. I just want to draw attention that I filed those this afternoon.
Obliged to, Lord.